Chairman Lingerfeld, we're on the record.
Hey, good morning, everyone. It's now 9:07 on January 24th, 2019. I'd like to welcome everyone here and call the meeting to order. And in doing so, I'd like to read that notice of the January 24th, 2019 meeting of the Board of Examiners for Land Surveyors was posted to the Board of Examiners for Land Surveyors website on January 17th, 2019. Before we adopt the agenda, do any of the members have anything that needs to be added, manipulated, or anything of that nature?
Mr. Chairman, I don't have any changes or additions to it. I do just request a little freedom on the agenda to move items around, just in the interest of time and efficiency.
Don't have any issue with that? All right, we will do so. And part of that movement will be to accommodate our guests so that they can get their business taken care of, if that's all right.
Absolutely.
Okay, that being said, need a motion to adopt the agenda.
So moved.
Second.
All right, we have a motion and a second. All those in favor?
Aye.
Opposed? Okay. Okay. Next item on the agenda is to review the October 25th, 2018 minutes. I hope the members have received those electronically before the meeting and have had an opportunity to review them. Additions, deletions, or corrections, we can take care of those now.
Mr. Chairman, if there's no changes to the minutes, I move to approve the minutes.
We have a motion to approve.
Second.
And a second. All those in favor?
Aye.
Opposed? Okay. Okay.
Matter of fact, I hate to interrupt you,
Yes, ma'am.
Tim, if I could.
Certainly.
I'd like to, even though with just 4 members it's easy, I'd like to go ahead and call roll real quick,
I apologize.
if that's okay. No, that's,
Yes, ma'am.
that's on me. Tim Lingerfeld,
Here.
Jay Kaufman,
Here.
Jackie Dillahay,
Here.
and Jed McKeon.
Here.
Thank you, all present. And the only other thing that as I'm looking at January ending that I did not add to your agenda, but we typically do, this board always selects the chair and so forth a little bit prior to the year. So with that done, I missed adding Robert's Rules of Law as our form to conduct business. So if we could, we will add it to the minutes when we post, just a standard process. Most of the programs go ahead in the first meeting of the year, add that we will follow Robert's Rule of Order to conduct our meetings, and we would need a motion to proceed with that.
We have a motion for that?
And if you have any questions, obviously Ashley's the expert.
So moved.
Do we have a second?
Second.
Okay. So this board will continue to function under Robert's Rules of Order. And if we get out of order, Miss Ashley will correct us.
Thank you. I'll turn it back over to you.
Okay. Moving the agenda around a little bit, I'm going to go ahead and, if it's all right with the board, to ask Mr. Mario Forte to make his presentation.
Thank you very much, Mr. Chairman, and to the board for having me here today to discuss what I've got planned for our TAPS annual conference and hopefully for some future plans for continuing education.
Mr. Forte, if I may ask you just for the record to state your name and address, please.
Sure.
And then you're more than welcome to continue.
Yeah.
Thank you.
Mario Forte, Forte, and I'm from Chattanooga, Tennessee. Tennessee license 1959.
Thank you.
So what I've working with the chairman earlier this year, we discussed an idea I had about working on a standards of practice that could be used across the state for continuing education, whereby it's an interactive process where members of the audience can participate either by using their smartphone or by just watching what's going on the screen and participating. So what I'm going to show you is the format that it is in a basic format, and the questions, the type of questions that I've asked that came straight out of the book. Now, I would have added 2 or 3, possibly 3 false answers but one of them is true, as you can see by the check mark there as to leveling survey means a survey involving the control of levels for land areas with a common datum is necessary. So that's the true answer. So the question will come up, and people can essentially download a phone app called menti.com, put in that code. I think we used it last year at the conference and participate. And we had about 250 participated last year in the Menti program. And this is not to be judging who's answering correctly or not. It's more of a data collection process as to who's answering and what do they know about this part of the law. And what I think we can do with this ultimately is be able to identify areas of the law that either surveyors are not conforming with, maybe they don't understand the law properly, and it's something that we can address in future seminars when we get the data back, so we can look at it and see, well, a lot of people answered certain questions this way. So is it an interpretation of the book that they're misleading, or they just don't know it and they need to be educated in it? So I think we have an opportunity for a lot of data to come out of this, which can be which is stored at the end of every survey that's done. I'm going to go through the presentation real quick, just so you'll see how it shows up on the screen.
Mario, may I ask a question real quick?
Yeah.
You mentioned about 250 participants in last year's use of this
Yes.
software,
Yeah.
or app, I should say. My question really leads to the results that you get on a per question basis.
Right.
Is there any trail that leads to the actual identity of the individuals?
Right,
I want to make
so-
sure that there really is not. I
Right,
think it's
so-
important that we're not aware of who
Right.
answers how. And I
So-
want to make sure that's
Yeah, so one of the things I'm going to do when you log in, when you sign in Menti, it asks for you to enter your name. So I'm going to instruct people to enter an adjective and a noun, such as fuzzy rabbit or something like that, so it's not associated. Now, if people want to put their name in, I'm not going to stop them from putting their name in, but it will track people's names in the software as it goes through, because it gives points for every correct answer.
I just want to ensure that for the purpose of security and privacy of the individuals themselves, that there's no appearance
Right.
that the board
Is-
gets names to answers, whether positive or negative, correct or incorrect.
Right.
I don't want anyone to have that
absolutely
idea.
stress that point, that this is not a data collection to see how an individual is answering a question. It is not about that. It's more about a broader look, because people will try to answer fast and they'll probably push the wrong button anyway. So you can't really hold people to what they push on the button. This isn't a test. It's an interactive, sort of a fun experience in learning, in my opinion. And I want to approach it that way. So I'm going to encourage people to use an adjective and a noun for their name. To make something creative, and I will emphasize that point. So, for example, it takes there's about 15 seconds to read the question and about 30 seconds to answer the question. So, for example, leveling survey means a survey involving the control of levels for land areas where common datum, and then people answer on their phone is required as necessary or as suggested. And then it'll go through and it'll show the real live answers, and we can pause at that point and just have a little discussion about, okay, well, the majority of people got this right, or certain people. And so I'm going to go through, there's only about 20 questions. We're just going to go through the questions to make sure the board is okay with my questioning. Okay, and if there's any specific questions that you would like added, we can certainly add them on here. So I just went through every section of the book, of the code, and picked out an item that I thought would be a good question. So this is really at my discretion of what I picked out, but if you've got something that you'd like to see in there, we can. That's one of the reasons why I was here, because Tim wasn't able to see the questions. So I'm sort of showing them to here. So here's the next question. Property lines are not actually property lines which are not actually surveyed must be clearly indicated on the survey plat or map. True, false are at the surveyor's discretion are the choices. Obviously, it's showing us here what the correct answer is. The next question is.
Mario, real quick, would these questions be available just on like a printout or an email that you could send to us to review? So we
I
get a
tried
little bit
to
of
do
time
that, and it
sit
wouldn't do
down.
it. It wouldn't do that. This will go really quick for us. We don't have to go through them all if you don't want. I just want to make sure that you understand that I covered all aspects of the book. Electronic survey documents such as CAD files are considered drafts, preliminary, as good as paper, or final. So people will answer that, and there's a clock ticking at the bottom left there that shows they have 3, 2, 1, and then it'll. What I thought was there's a couple of questions that relate to mapping and platting, and I think it will be interesting to see, for example, like if you use GPS, there's a question later on, if you use GPS and you use ground terrain surveying methods, which certification do you put on? You put one certification, you put them both, do you combine the certification? It'll be interesting to see what choices people come up with on that, and maybe we can have a discussion about that and clarify that for people, because I know that the GPS and not everybody is completely familiar with doing that. I know after we get questions all the time about how do we fill out this form, how do we chapter it, so I know this is going to come up in
Real quick, the venue that this is going to be offered, is it a question and then question the board members type situation where we could answer why this or how this or refer to this, or is it just strictly?
So it's going to be questions and answers, but because the way that the format is set up is we've got 3 PDHs. 1 hour of that is standards of practice. So we can choose, if we like, to address an issue as it comes up. Like on this question, we can actually have a discussion like what we're having here.
Okay.
I haven't started the next question yet. Or we can choose to go through the whole process and then come back on it. And, like, if you want to make notes and something, okay, let's go back to, and we can look at the results during a later on and say, okay, let's look at that question again where people answer this, and let's go back and have a discussion about that.
I think if that's the case, I definitely would like a copy of these questions before, just so I can be a little prepared ahead of time in case,
That's actually why I'm here, because I couldn't, either I'll type them out and send them to you, or I have to go through them one at a time here. If you're good with that. So I'll be happy to type them up and put them out. I couldn't export the questions.
Okay, I would prefer it typed up.
Yeah.
Just email or something.
I'll be glad to do that. And if you've any you'd like to add specifically, I'll be more than happy to do that. There's plenty of time in there to do that. If there's a specific question you want. Again, this isn't to trick the audience into answering wrong or right. This is a way of educating to find out what people actually know without looking at the book and what they're doing in their daily practice and seeing whether or not it conforms to Tennessee law. And what I would like to do with this, if this works well, is be able to have the chapters present this at a local level. So at various parts of the year, if they need to get their PDHs for their local chapters, the director can be the person that's running the survey, the chapter director or the chapter. So with that, I know when we fill out the PDH form, we need to know who the speaker is and so forth like that. So what I would be asking of the board is that if we get the PDH for this type of seminar, that the presenter would be a director of TAPS, if that's acceptable, if that's an If this works too, it's possible that we could do something like this for ethics as well, so we combine standards of practice and ethics. And the results, if I get to the, if I break out of here and go, the results of the quiz, I've got a lot of user options here where I can find out all of the, well, it'll give a score of who actually answered the most correct questions, but it gives an actual score of, on each answer, how many people answered this question, how many people answered that question. And I think we get a good idea. Let me see, I've got 22 questions here. Geodetic control surveys must be made in accordance with the Federal Geodetic Control Standards, the Tennessee Code, or so I think there's a good range of questions here. There's RTK GPS, pretty much everything. I went through every part of the code and selected a question out of each. And we can add to this, we can expand it, we can do whatever we want with it. So that's pretty much what We'll be glad to type these questions up and send them to you before the conference so you can have a chance to review. Very easy for me to change them in the computer before even the day of.
Thanks, Mario, and I appreciate you sending the questions to us. One question is, I notice in the TAPS brochure that this window of time is for 3 hours. I would assume, but you can tell me, that you want the board to make some type of normal presentation as we normally would. Okay.
So essentially, however long this part goes, the remaining part would be either Q&A from the audience if they've got any specific questions. And it can be done in a format because we have this software running and because people are signed in, they can actually ask questions on this.
There you go.
Okay. For an opportunity, if someone wants to ask an anonymous question to the board, there's using the software to do that. So I would assume that 2 hours is quite a lot of time for Q&A. So I assume that there would be something that you might like to present. I know you did last year. You presented 2 topics last year. I think there's a lot going on in the survey world, like with what's going on in Kentucky like that there might be an opportunity to talk about that in front of the surveyors and so forth.
I think as the meeting goes on in our new business, we actually collectively have not really discussed anything as far as what may be involved in that presentation, but I think with Ms. Roxanne's assistance and direction, I think we can probably craft a topic or two that we feel like may be the most pertinent issues to us that we want to relate to the licensees that are in the room, and then it may go from there as it usually does.
I will look for your guidance as to whether or not you want to use this software for Q&A or whether you want just people to come up to a mic and ask a question. It may get to a point where there's so many questions coming in you can't get to them all. So we don't want to get to that point too, but you kind of want to address if everybody has a question. Or if it's running slow, maybe you can offer it up to people to ask a question through the.
I want to say that I think this is a very good format. I enjoyed what we did last year at the conference in answering these questions. I thought it brought a good level of interaction because, as in any large group, there's always just a few that will speak, and there's a greater number that will not. But in that non-speakers, there's quite a few people that would like to really ask a question, but if they've got to stand up in front of that microphone in front of their buddies, they're not really willing to do that. But in this manner here, it gives them an opportunity to do that because everybody now is so user-friendly on their smartphones, text-worthy and all that type of thing. You know, it's a no-brainer almost.
And the thing I would like to point out about the actual questions that we're doing is that people don't have to log in. People can still look at the answers on the screen and decide what the right answer is without actually participating in the game. So they're still getting education value out of it because we're going to talk about the answer when it comes up. The answer is this. It's an opportunity for people to have audience participation, but it's not mandatory. That everybody wants to participate.
Right. Okay. Anybody have any questions for Mario on his presentation at this point in time? Ask.
I think it's great. Great idea. Yeah.
I certainly appreciate your efforts, and I hope that this is a foundation for something more in the future that's more broad-reaching as you've addressed.
Thank you.
And you will send us the questions.
Yes, I'll send them to you this week. Yep.
Hey, we'll discuss when we get to new business a little more about what we think we might want to talk about and our a part of the presentation and so forth with Ms. Roxanne. Okay. If nothing else at this time, if it's all right with the members, I'll let Mr. Winter, who is the current president of the Tennessee Association of Professional Surveyors, come forward, and I think he wants to talk with us about a few things. want to thank you too, Mario, for taking your time to drive up from Chattanooga to speak to us about this, and we look forward to seeing how it works.
All right, appreciate it for you letting me come here and talk. Again, my name is John Winter, Knoxville, Tennessee. I'm the current president of TAPS. I'm before you with no arguments or complaints. I'm sure that's something you don't get very much. Really, it's a couple simple things. First off, I wanted to thank you guys for clarifying the PDH review process and why it took so long previously, and that you guys are working towards speeding that up. I think that's going to be really, really important. Not turning in your PDHs, where each person is responsible for finding their own, and how people put stuff off toward the end of the year, and then if you get audited in January or whatever, your stuff may not be approved, and you're trapped. Second thing is we had a request, and I can't remember if it was at the board meeting or if it was at our local chapter. Someone had requested maybe a simplified description of the education requirements. I know when you get on the board page, it's like, it's all text on, surveying degree or non-surveying degree with this certain degree, but this many classes or whatever. If there's some way they could have something that was more of a tabular form or something that they can hand to people or show them on their phone. Text involved in each direction or path that you do, but I don't know.
And I can maybe, to not interrupt, so we don't forget, so because it's a regulatory board with laws, they really can't be simplified. We actually point people to the rules. Thank you. The rules are similar. We would point to it. We may have a policy or two, for example, the different categories of courses that people can take. That is sort of in a policy format, but simplified rules and laws really we just avoid, because that's the reason they meet legal's true definition of what needs to be done. So,
Okay.
Well, I would really, Mr. Winter, refer you to Public Chapter 714, which is our licensing law, and basically under the portion that describes how an individual is licensed in the state of Tennessee as a land surveyor, there's 5 particular paths. And I feel like that basically each of those paths are really pretty straightforward, because the point of those paths basically boils down to 2 simple areas. One is getting through the FS examination. Okay, that's the preliminary examination. Start at that point in any of those 5 categories that's listed in 714, then you should be able to understand both experience and education for each path that you would go. That was written, it tried to be written as simple as possible, but please understand, as with any legislative action creating a law, we have numerous attorneys and different people that look through all this stuff, and a word that the board may choose to use that's simple or commonly used may get changed to what I would call a legalese, and it does complicate the quote definition just a little more than maybe it should. However, I think that this one is generally pretty straight forward, and if I'm sure that we could answer a question or something if you had a specific question or whatever about it. But and I understand where Ms. Roxanne's coming, and she's right. If the board says, you do item number 3 in this manner, and we err whatsoever, then now our attorneys do have an issue.
I get that.
So,
I understand that.
yeah.
Yeah, I get that. Okay, they were just it came up because somebody was they were talking to some young folks, and they were like, "Well, what's required?" And they're like, "Well, I think it's 4-year degree or 4-year degree plus these hours or this degree plus those," and they just were like, well, they were trying to give them something quick and easy. And I understand that that's maybe not something that can come from here. Maybe that's something that maybe a TAPS can maybe do something kind of general and then say, hey, you guys need to go look at the act.
Well, I can honestly say that I spoke at the exam prep class last year at the TAPS meeting to the folks that were in the room, and that was some of their questions about, when could they take the FS, and, what happens when they pass the FS, and that type of thing. And those are questions that I tried to answer for them. And because most of the individuals in the room really were kind of confused. They didn't know because they had not had the same direction. And that in itself may be potentially a topic that the board might want to bring up before the licensees, because ultimately the licensee is the initial go-to individual for their employee to work towards the path of licensure. And it's important that our licensees do understand exactly the question that you're asking.
One thing we had was on flood certificates, flood elevation certificates, and somebody wanted to know, is that regulated by this board? I would assume just the surveying aspect of it is, whatever you're doing surveying is covered under our laws, but I didn't think it was addressed or covered by this board at all, correct? Messed them up. They're not gonna come before y'all, or, you don't, just the surveying part is what we address, I assume.
I would think, in my understanding, and obviously I've done many elevation certificates before, I don't know that they fall under the regulatory rules of this board other than the direct aspects of the survey itself.
That's the way I understood it. I just wanted to make sure that was asked me, and I didn't want to tell tales out of school, tell them the wrong thing on that. And the last thing that I had was just, and you've got it on your agenda, is the news coming out of Kentucky with them dropping their state-specific. That's a little shocking, I guess, for me, but outside looking in, because I had to take it in 2010. But I was curious what was going to happen with that, and what are we going to do here? So I guess you guys are going to address that.
Yeah, we'll talk about that in new business.
That's all I have. I appreciate your
Okay.
time, and if you have anything you want me to take back to TAPS, just please let me know.
Thank you.
Speaking on that, if I could, just 1 minute real quick. There is a topic I think we'll address here a little bit later on this afternoon regarding the 2022 State Plane Coordinate System. That is a legislative action that needs to be addressed by the state. And it will need, when we do get to that point, it will need a sponsor organization to push that through legislation. I would like, if you could take back to the TAPS board, just that beginning mention that it might be a good idea for TAPS to be that sponsoring organization. Perhaps they could sister in with TDOT or somebody to that effect. But we would ask.
Maybe unpack that for me. It's not a done deal. You're saying it's something that we're going to go to that, and then
We're going to go
it's
to
not
it.
official, but
We're going to go to it, but there is a legislative action. It's really just a
Technicalities,
technicality,
essentially?
really, is what it is. But it has to be done.
Okay.
And it has to be pushed through, and it has to have a sponsoring organization. So if you could go back and TAPS with that idea and kind of put it in their mind, you may want to talk to their legislative representative. I think it's the Bivens Group, I think it is, and kind of get that wheel start to turn a little bit.
It needs to start
Now,
pretty soon because of the process. It'll take that long to be in effect by 2022.
oh, wow, okay.
Yeah, and see, our current, deals with 83 basically for the most part. So it's got to be basically that just has to be updated. It's more of a cleanup, an update because of what the federal government is doing, but it's a process that has to go through the legislature in order to change ours.
Okay. Yeah, I'll see if I can contact him and ask him what we need to do moving forward, and then get with the board at the next meeting and see what do they want to do. I mean, I'd like to see what they want to do. That's all I had.
Thank you very
Appreciate it.
much.
Thank
We
you.
appreciate you taking your time to drive down here and be with us today.
Thank you.
Okay, I think we'll get back to the regular agenda, and I think we're up to the education report, Ms. Roxanne.
Yes, sir. On your iPads, we start on page 11, and the courses that are on page 11 through 14 are those that were submitted to us, and if I'm incorrect, Jamie will, obviously she's the expert that handles these, she'll correct me. But 11 through 14 are those that need the board's approval. They've already been reviewed by everyone, and the current pending ones start on your page 15. And so those, if you'll take a look at real quick and get us the final go, as we've said, once the board members approve through the email and are individuals that review them through email as well approve them. We're pretty set on these. After page 15, on page 16, we have some communication of those that are pending and possibly not approved that we can then have further discussion on.
Starting on page 15 are the ones that we're going to talk about, correct?
Page 16, actually, yes. So through 15, I want to make sure that everyone's comfortable with those. They've been approved by board members.
My page 15 starts with pending education on mine.
Correct.
Is that what you're saying?
Correct.
Yes, so pending education, you are approving as well now. Page 16 are our problem ones.
So we do nothing with page 15, is that what you're telling us?
No. Page 15.
No. Page 15 deals with our problems.
Okay. Got paperwork on that as well.
Yes,
You are
ma'am.
Correct. Okay.
Well, we have some paperwork, yes.
We do.
11 through 14.
We have 11 through
have already
14.
been approved, it just
Okay.
needs your approval.
Yeah, we have 11 through 14, and I think we have seen all of those. As the members saw, 11 through 14. Not, we'll take time to review those.
Okay. Are there any concerns from what y'all are seeing on page 15, if that's what we're reviewing?
We haven't got there yet.
Oh, okay.
We're still on 11 through 14, making sure everybody's happy.
She said we have already approved them.
Well, that's what I'm saying.
Record you need to.
I just simply asked
We
if
need
there's
to
any-
approve them on record now.
Okay.
Yeah, if there's any other concerns on 11 through 14. Okay, if no one has any problem with 11 through 14, may I have a motion to formally approve?
So moved?
A second?
Second.
Okay, all's in favor?
Aye.
Okay. All right. Okay, Ms. Roxanne, now we're on to some pending items, I think.
Yes, sir, and you do have an added paper document from Mr. Thompson that was just sent in after we loaded the iPads and had everything finished, so I do want to make sure to refer you to it. So what's pending starts, you are correct, and I apologize, on page 15, and you have quite a bit. This goes all the way to page 33, with some courses that, again, were not approved by our reviewers or you also. We want some guidance on how you want to handle. And you, by all means, take the time to review it.
I have a notion, and I'll just throw it out to the board, that possibly we review this maybe when we return from, so that we make sure that everybody's had time to read all these, because there's quite a bit of information there that I have not seen. And
For the 2 cents on page 16, Mr. I guess it's Mr. Roberts, recites a fairly succinct analysis of what he thinks about these page 15 courses, the first paragraph there.
yes, and Mr. Roberts, for your edification, Jed is one of our advisory committee
Gotcha.
members. Well, if staff and attorney has no issue, we will sit here and review this. And it may
That
take us a
sounds-
few moments
absolutely.
to read through this and in order for us to be able to handle it. Roxanne, I note in one of these, I don't know if they're emails, letters, or what, pages, one speaks to a petition, sorts, those are not included in what I'm seeing here. Petition for legal reasons, or
That on the emails from Mr. Roberts?
it's on page 22
Okay.
at the bottom.
That wasn't included in the email that they sent to me yesterday.
Gentleman spoke to it but did not include it. Okay, thank you.
Roxana, on page 29, are these pending courses also, or the? Okay. All right.
You'll follow, the next email kind of addresses them and the concern about them being correspondence courses as opposed to online. So it looks like proved these kind before. So it's
Oh, they have never been proved before? Okay. Yep.
Okay, I think that the members have reviewed a lengthy amount of information on the first pending case here. I might ask Ms. Roxanne and maybe Ms. Ashley, one of the things that stands out in some of these emails, I assume all these are emails, some of these that I've read is the question to what this board determines correspondence versus online courses. And I wonder, before we break these courses down and have some type of discussion about each or so forth, I wonder if it would not be prudent for us to discuss that very issue and come to some type of resolution prior to moving forward.
Talking exactly about that, especially if correspondence courses is new to the board itself.
So per your statute, specifically 6218-106, as y'all know, the board has the authority to establish continuing education requirements and standards for land surveyors, and we would find those in the rules. I think at this point, our rules don't address correspondence courses, and so before I could give an answer on that, I would need to fully understand what correspondence courses are and the difference between that and an online course, and do some research into it if you wanted a legal opinion on it.
Okay, well, let me give you an old guy's opinion of that. Many years ago, there was a school that was called the International Correspondence School. It may still exist, I don't know. But they had a program for surveyors, and it was called ICS Surveying. And that program was basically a correspondence program. What they did was they provided information to the individual that was going to take their course after paying the appropriate fees, etc. And that individual did their study, sort of a self-study type course. And there were examinations that were part of that course, up to and including showing mathematical calculations, drafting, a variety of things. And it was a sequence of courses that would basically get a surveyor at that time a certificate of passing that coursework. And that certificate at that time also assisted in some states or jurisdictions for the surveyor to that be a step in the process towards licensure. Okay, so that process, you would study, you'd take the examination, you'd put it in an envelope, and you'd mail it to somebody in Chicago, and they would grade your test. And when they graded your test, they would respond, particularly with two things: one, your score, and two, the points that you missed. They would kind of define those for you so that you could help understand, because the next examination that you may take in that process may rely on some of the information that you had already studied on, as it normally would in any like college course or whatever else. So that basically was, in my mind, the premise of a correspondence course for a surveyor. Now, that's been obviously many, many years ago, and things have greatly changed since then. However, when I first came on this board, we had issue with, and I know Jackie will remember, he was on the board at that time too, we had issue with online courses. And we were finding at that time that online courses were asking for a large number of hours. And you could take that course in a matter of minutes. So we did not have the balance. So at that time, the board made a policy that said it took 4 internet hours, basically online hours, to get a credit for 1 hour. So you had to 4 to 1 was the ratio. Okay. Well, as we move forward, and I know this is probably too much history for you, but as we move forward into the continuing education rule that we now have, one of the things that the board was concerned about was what I'm going to call non-seat time. Okay, many professionals, and I think, Jed, you can correct me if I'm wrong, but I think the attorneys have to have seat time for all of theirs, don't you?
Not for all of it.
Okay.
About half can be online, actually.
Okay, well, that's good. Thank you for knowing that. But some professions do pretty much require seat time. We did not want to, when we were looking at the rewording of this and so forth, we did not want to have to go to 100% seat time, because we felt like that was problematic with some of the registrants, and also created potentially some undue expense to get the same amount of credit that someone else may get where it's close to them versus having to travel a long way, spend the nights, etc. So we looked at other things that could be accomplished, and that's where the basic requirements came from for what we were trying to get at. So I guess the moral of that story is we were trying to, this is my opinion, but we were trying to get away as much as possible from just pure online courses. We felt like that a correspondence course would provide a better level of interaction for the individual taking the course with the individual teaching the course. So that's what we were trying to get at with the correspondence course at that time. Now, whether we've accomplished that or not, I don't really know, because we collectively, I think over the last several years, have not had that many courses that have actually been applied for straight up as correspondence course. Primarily, they're applied more so for seat time. For example, just like TAPS. All of TAPS hours are seat times, whether they're at the annual conference or whether they're at an individual chapter meeting. And obviously, there's merits both ways. But again, going back to the correspondence course, I just feel like that there's a specific level of interaction that needs to happen in order for that to fall into that category. In other words, you can't just order my course and I send it to you and you send me back an answer sheet and we're done.
Let me ask a few questions. What's the yearly requirement for hours?
We have a biennial requirement of 30 hours. 30
hours. For example, and attorneys think they are very important. So they have 15 hours a year, same situation, and 8 can be distance learning, which means online essentially. And if I want to do something online, I can pay $30 and watch a PowerPoint presentation, and as long as it plays to the end, I can click that I watched the whole thing and be done with it. I mean, I don't know what the board wants to do today, but it would make sense if you were able to do at least some of those hours distance, correspondence, or online. And I think we had this discussion at the last meeting when Jay said, I have a drawer at my office that has all my hours, and it's the honor system as to what those hours are. I think it's the same deal here. If you wanted to put honor system on some of it but in seat for some of it, that makes sense, but maybe we're not at that point yet.
Well, good point, Jed. And to follow up on that, at the same time we went to the 4-to-1 ratio on the internet, we also stipulated, and I think that was in a policy, that 1/2 of the 15 hours could be, no more than 1/2 could be done online at that time. But when we came to this new rule that we have before us, that language was not incorporated.
Sure.
So we have a situation now to where we've got to kind of, we've bought a new box, and now we've got to play inside this new box.
I understand.
Basically, your point's well taken, and I don't necessarily disagree with it. But again, going back to what we're trying to accomplish, we've got to kind of come up with something so that we can move forward with these courses that we have before.
And if that's where we're at, I mean, aren't we in a position where we can approve all the hours that these people are asking for that are in-person hours, and then reserve judgment or ruling on it until we get a legal opinion on it? I mean, can we do that?
I would think that we would. I'll lean to our expert back here, Miss Ashley.
I'm not aware of any rule or statute that would prevent you from being able to do that. Like I said, per the statute, the board does have the authority to establish requirements, and your requirements are listed out in the rules, and then also you have the additional policy that discusses it. So I think that would be acceptable.
Well, that policy statement went by the wayside when this became the rule. So technically speaking, we don't have a policy statement. So, attorneys heretofore have directed us not to have policy statements as much as possible, and we understand that. However, this situation, in my mind, somewhat alludes back towards one, as explaining what this says. Again, going back to my explanation with Mr. Winters back there of the simple versus the legalese, and we kind of have the legalese now, but yes, the board does have a reasonable amount of discretion with this. So how does the question then, Bodes, is how does the seminar presenter or the licensee know what the board feels like this item is? I think that's the gorilla in the room.
So what you're saying is, if I understand correctly, don't make any policy about what we're going to do in the future, but just decide this on a case-by-case basis as it applies to these two, and just do the best we can? Is that what you're saying?
Well, that's from the spirit that we get that we're not supposed to make policy.
And I think I agree with you.
Yeah.
Okay.
Yeah.
I mean, I'm fine with that.
Well,
I will
Yes,
point
ma'am.
out that they have the rules with them, right?
Yeah,
Yeah, so
right.
Rule 0820-05-.05 talks about types of acceptable continuing education.
Right.
And specifically, item number 2 provides the board will grant credit for only such continuing education activities that satisfy the following criteria, and then it has A through E listed, and then number 3, the board will grant no credit to a registrant for a course, technical meeting, seminar, webinar, or tutorial repeated by the registrant within 3 years. So you have guidelines in the rule for the board to consider continuing education and decide whether that is satisfactory per the specific A through E subsections in there.
Hey, let's do that on the spirit of what you've said and what Jed said, since we're getting attorneyed up here pretty good.
You're very lucky.
And that's fine. I have no issue with that. Some of my best friends are attorneys, and I hope that you all come at one of these days.
Not if I have anything
I
to say
understand.
about it.
Thanks, Jed. I appreciate that. Why don't we approach it this way? This is what I'm hearing is, why don't we let Miss Ashley look at that just a little bit and see if there's something that she feels like that that legal would be comfortable with in that regard, I'm going to say the spirit of definition or / policy. I'm just going to say it that way, and I think we understand what we're mentioning here, and move forward, because the one thing I can say about the cases that we have pending before us, there's a lot of information that's been provided to us. We've read a lot of information. There's a lot of different sources that's brought that information to us, up to and including our advisory board and others. And I think that Jed's right that we look at these just as case by case as they are, and let's just move forward with them and handle it in the manner that the board should handle it, if that's satisfactory to everybody.
Ashley, do you understand what we want you to do?
I think so, but if you want to clarify, I would be okay with
Go ahead,
that.
Jed.
Well, I was going to look at Tim and ask him to do that. So if I'm stating what Tim wants us to do correctly, I guess we want some sort of advisory legal opinion as to what whether we should approve these courses based on our non-policy of regarding correspondence and online courses. Did I say that correctly?
That's fair.
Board?
Yes, sir. Yes, sir.
Jay, Jackie, any other thoughts? Okay.
If I could add the only other piece, all of our members, and Jed, you would be excluded, have had an opportunity to look at the substantial pieces to these courses, correct? Through email. So they've actually not just read the title, witnesses, and 10 different courses that are stated as expert witness and several as Clark 1, 2, and 3. They've looked at the material. So taking into account that the material itself looks like it meets what continuing education courses we'd like our licensees to take, I think that's the big piece. Are we really that concerned about whether it's online, coursework, or in person? The statute, at least I believe, and so Ashley's going to review it, allows you to approve it regardless of the method.
The only other question I have is, it doesn't appear that to be, I'm assuming we're meeting next in April or something. Is there any urgency to approving these that?
Well, I will say this, the group of courses that we have before us, the gentleman that is bringing those before us has brought them before. He has personally appeared before this board. I feel like that in no uncertain terms, we owe him a response, whatever the board decides that response is for his stuff.
What about this other person, Lucas and Company, on page, that has pending case on page 29? Did y'all look at those? Are we in the same boat on those ones?
My initial reaction would be no, we're not in the same boat.
Okay. So that is our decision on just Mr. Thompson, I guess?
Yes, sir.
Okay. Actually, you got all that? Okay.
Yes, I think so.
Okay, good.
Mr. Chairman, could I jump in there for
Yes,
a minute?
sir.
All right,
Please.
look, I think we need to, I think we've beaten that horse pretty good. And I don't know that we've really addressed the direct issue here of addressing each of the individual courses that Mr. Thompson is applying for, which I think really is where we need to make the progress here. And as you stated, Mr. Chairman, earlier, Mr. Thompson deserves a response.
Yes.
He's been kind of put through the woodshed here. Whether it's in favor or not, is something we need to make a decision on here, addressing each of the individual courses that he's applied for. And I would, with all due respect, Mr. Chairman, ask that we as a board address these courses, and whether approve or disapprove, agree with or alter the number of PDHs requested on each one. But I do think we do need to make some progress on this here and get him a response.
I don't disagree with that. I think Ashley's information is valuable going forward, but I agree with you, Jay.
Oh, that doesn't discredit anything that we're asking Ms. Ashley to take care of for us in terms of the legal aspects of it. But I think when we get down to the meat and potatoes, down on the layman's issue here, we need to address this for Mr. Thompson and any of his potential future clients that may take these courses. So with that being said, Mr. Chairman, I'd like to address these individually, as he has applied for them individually as a board, and make a decision on them individually, not collectively, if that's okay with you.
I'm going to let you lead the charge, Mr. Kaufman.
I'd be glad to take care of that. All right. If we could, then I'm just going to go by these item by item, and we'll try to go through these as quickly as we can. Obviously, if there's any discussion, I'd like to hear it. Items as they're labeled here on our page here: S1, the introduction to GPS of 8 PDHs. And then I would like to, unless there's any disagreement, kind of incorporate that with item 2, S2, advanced GPS, also requesting 8 PDHs. Requested.
I apologize. Are you on page 15 of his list?
This is page 16.
Thank you.
Oh,
Okay.
Or is it?
Page 16
of
16
the.
Page
of the problem.
16.
Okay. We're good.
Yes, ma'am.
Okay.
Yes, ma'am. If I can make just a suggestion first, my personal suggestion, having read the provided information from Mr. Thompson as well as some accompanying emails, my suggestion would be a combination of S1 and S2 put together for the total of 8 PDHs, or if he prefers to offer them separately, 4 PDHs on each topic individually.
We want to address those, comment as you go along.
Yeah, individually.
I would agree with what you just said.
But what I laid out there was an option to either combine or individual 4 PDHs. But I guess actually I want to revise my own recommendation. I don't want to lead Mr. Thompson as saying he should combine his courses. Those are his courses. My suggestion would be for both 1 and 2, a recommendation of 4 PDHs each as opposed to the requested 8 PDHs each.
I agree with that.
Do we want to go all the way through the list and then just make one motion to approve as we've decided?
I think
Or
so,
do we wanna do
unless-
course by course?
Totally up to you. Unless you're disagreeing with Jay, we can kind of keep going, make a note if you don't agree. But if
Okay.
we are following through and letting him be the charge, Jamie and I are going to take good notes so we
Okay,
can follow
okay.
up.
Go ahead,
Okay.
Jay.
Okay. Well, again, just to restate, item 1, the introduction GPS, my recommendation is 4 PDHs, as well as item S2, the advanced GPS, my recommendation is 4 PDHs. Moving on to item 3, the geocaching and dendrology, I'm in agreement with the request of 8 PDHs. All right, hearing no disagreement, I'll continue. Item S5, as listed, Tennessee State Plane Coordinate Systems, I'm in agreement with his requested 8 PDHs.
I agree.
On to item S7, S8, and S9 entitled CAD Drafting 101, 201, 301. He's requesting 8 PDHs each. My request is to alter those to 4 PDHs each. Okay, moving on to item S12 as listed.
May I address Mr. Kaufman?
Yes, sir.
On those 3 items, reading his syllabus, 4 may still be stout. 4 hours may be still much.
But what's your recommendation there?
First 2 courses are pretty basic.
They are.
I would have said probably 2 on each one of those. And I want to make this statement too. I think it's incumbent on this board to understand the level of continuing education that is appropriate for a licensee as opposed to someone who is involved in surveying. I think that's very, very important. Again, I've read the associated emails as well, and that's why I question some of these courses, is whether we're trying to teach someone that's going to become a surveyor, or we're trying to teach a surveyor to improve their abilities and knowledge and so forth. That's my biggest concern.
Yeah, Tim makes an excellent point there when it comes to PDHs, and if we could just kind of remind ourselves, the definition of a PDH is a professional development hour. It is not a technician development hour or a in-training development hour. It is for continuing education of the professional already licensed. CAD drafting 101 for a professional is, I don't know, it's somewhat misleading, I think. And so that was the majority of, and in addition to my review of his material that's included in that corresponding class, that was my suggestion as to why I kind of lowered the amount of PDHs being offered. And Tim, I think you were suggesting we lower it even more so to.
And our advisory committee asked that we deny the course. So, we're somewhere from 8 to 0.
My basis behind it is that the professional surveyor these days, for the most part, the old school of the professional in one category and a technician doing the drafting has pretty much been eliminated in most parts. So there is some value to the ability of the drafting, of being able to display his professional product. That was my rationale behind not denying the courses completely. However, in review of the coursework that he has outlined, I did find, especially the first 2, like Tim mentioned, to be somewhat rudimentary, if that's the right word for it. But I do see there is some value toward the professional there. I don't think it should be denied completely. And so I'd be willing to agree with the chair there of a recommendation of 2 PDHs on, if I understand you correctly, 2 PDHs on both the 101 course and the 201 course. And I think you were in agreement with me on the 4 PDHs on the 301. Is that
Yes,
correct?
sir. Yes, sir.
Okay. Did I?
That's what I would be in
We're clear there?
agreement with.
Okay. All right. Moving on, unless there's objection to, we do have item S12, the Opus Solutions requesting 4 PDHs. I was comfortable with that. Item S14, retracing surveys, a request of 8 PDHs. I was comfortable with that. Items 16, 17, and 18 I'd like to address together. The request 16 being spiral curves, 17 horizontal curves, 18 vertical curves. Quite honestly, again, that's more a lot of, somewhat of a technical studying to become a professional. There is value there. I don't want to eliminate it altogether, but I do believe that those could either be combined into one course or, even though he has requested 4 PDHs on each of them, perhaps lowering that to 2 PDHs on each. I think 2 hours is adequate time for each of those.
I think 2 should be the max.
Okay, so 2 for item 16, 2 for item 17, 2 for item 18. Moving on to item 19, trigonometry, 8 PDHs. Again, I think that's quite inflated, having reviewed his coursework that he gave. Pretty much my same argument with 16, 17, 18. I think, honestly, I would probably lower that to 2 as well, is my request, unless there's any disagreement here. Okay. And this ought to be for a professional. These ought to be review courses. Item 20, COGO, again, 8 PDHs being requested. I think I would probably request that down to 4, I think is where I had that, because there is a lot of involvement in COGO. Any objections to that? Okay. Item 22, survey file management. My request was to deny that one altogether. The only thing that makes that survey related is the fact that he put survey in front of it. It's file management. It's just file management is what it is. It could be anything file management. How that is directly related to surveying, and I read the description there. I understand where he was going with it, but I just, in my gut, I could not approve that one for any PDHs. My request is to deny it. Any discussion on that? Okay. Again, item 24, the time. Is he requesting 4 PDHs, more of a time management thing? Again, that could be applied to any profession. I denied it as well. I just couldn't stomach that one, to be honest with you. Standard practice, 2 PDHs. My recommendation was for 1. That's the requirement. 1 PDH. If you're stretching that into full 2 hours of whether it's by correspondence or in person seminar type thing, you're really stretching there. I think 1 PDH is adequate on that one. I think that covers all 30 items there. If there's any discussion individually or group-wise, I think we've covered them all.
I think that was very productive.
I would move that we accept Jay's recommendations.
Do we have a second?
Second.
Okay, we have a motion and a second. Based on the list of courses and the hours that were discussed and assigned to each one of those courses, all those in favor?
Aye.
Opposed? Okay.
Are we willing to look at the Lucas and Company on page 29 the same way, or would we rather wait on these?
Or to wait on those a little bit?
Okay.
I need some time to kind of review those.
And I believe all of these are the correspondence
familiar with that
issues, so we can bring those back before the board at the April meeting if there's no delay. Obviously, we're also happy to send the information that Ashley may find, but I think in general the rule allows us to accept them, so we'll bring them back. Let us know if you think we want more information on them or anything at all. Otherwise,
These were just submitted like 3 weeks ago, I think,
yes, these are
correct?
fairly
Okay,
current.
gotcha.
And Jamie, did you sense when they were submitted to you a level of urgency from Mr.
Well,
Lucas?
I just put, that's the last that I have.
Okay,
And I put
okay.
those on there because they
Okay.
were pending.
'Cause I'm familiar
They
with Mr.
related
Lucas.
to the home correspondence as well,
Okay.
so.
Yeah, I'm familiar with Mr.
So we will let them know that these, right now at least, are being delayed for the next meeting, that legal counsel is going to do some research, and then we'll present else that we have on them, if that'll be helpful. Thank you.
While we're into this continuing education, can we broaden the discussion a little bit as well? And so we have I guess, a little better understanding of where our process currently is, just from a communication standpoint.
So we currently we had 3 individuals on our review group reviewing these first and through email. We're down to 2. So we would welcome if the board has a couple of names that we can rely on just to add to our bodies that we can distribute these on. So as they come into the office, all of the material is sent via email to our reviewing group, whether they're 2 or 4 individuals. Once they have approved them or denied them or given a response back to Jamie, then she sends them over to the board members to be able to review. If we don't have, and so right now they're going to 2 members, and I think at the last meeting we had said that within a couple of weeks we would make from you all reviewing them. If you need more information, let Jamie know through email. If you have a concern, let her know. If you are comfortable with the recommendation from the committee and you approve them, we can move these to go ahead and get their CR, their numbers and be able to be taken by our licensees. And that's our goal, that if we've got a member that is approving them, that you all will trust each other's judgment and get them out there. And so that's how we are working now. We can, at the forefront, put them into our system, document them better, so if anything happens and we have transition, we can always pull them. And if there are no additional questions, we can move them out. Anytime the board member that's reviewing them, whether it's Jay or Tim or Jackie, then we would either send them for another review if your thought is, I'm not comfortable with this, but I want another member to review. But if you have concerns, then those are the ones that we would be able to address then at the meeting.
So you're only doing the 2-member mail because of the majority,
Correct.
basically?
Correct.
Which that's different than applications.
Yes. Yes. And if all 3 of you want to see them, it's to take into account your time because you respect each other's positions. So, would there really be a need for one more person to review?
Okay, good. Now, let's talk a little bit about the continued use of CE numbers and their benefit to, number one, to you as the staff, basically.
You're referring to the CER number?
Yes, ma'am.
That we had? Yes, sir. So right now, our system can add, and Jamie will correct me if I'm wrong on any of this because I don't do these each day, so I know I'm going to mess up something. Our system requires us to do a little bit more with these land surveyor hours to create the CER number. Am I correct? They're not a fun task. They don't automatically do this. So as we move to the audit process, we could allow the system to create a number. It wouldn't be necessarily the CER number, but a number of its own that we would issue to the, so in this case, I'm looking at Lucas and Company's list. So they would know that instead of CER-19, 70-18, our system has given them a number of 25-whatever. It's a unique number within our system. That would work better for us because it'd be a lot less for us to manually have to do. It would still give it a unique identifying feature in our database so that we could publish it to the website, because the goal is for the licensees to easily go through the list and know what they can take at the end of the day. And for us to present it to you knowing that Clark 1 versus 2 versus 3 have a unique identifying factor number and the documents that go with it. We could move to that to make it simpler on us. But either way, I think we need a unique identification for each course so that every time you review it, you know what it's called in our database.
Okay, now, let's look at a sister board, architects, engineers. Do you do a similar process with them for theirs, or I don't think that you do anything, actually?
No, which is thrilling. I don't want to sound happy, but
I understand.
No, we don't have to. So, architects and engineers can take courses that are reviewed that cover the protection of the public in general. If the course is about protecting the public or the industry specific to improve, they can take it. They have to, when they're audited, because they've been on that for a very long time, they provide the name of the course, the certification, and who's reviewed and approved it, but it does not come specifically through our board.
Okay, let's stay in this spirit. We're getting places. All right, since we're going to an audit, and we're going to talk about that a little bit more later, but in the audit process, the burden falls on the licensee. If their number's drawn, it's on them, and they've got to prove to this board basically that their coursework, that they did the appropriate amount of coursework within the biennial period that they're being audited for, and that coursework meets the criteria that the board has set forth in the rules. So, having said that, I'm going back again to the CER number. And it sounds like what I heard you say was there's a simpler way for you all to function with it. Now, in that simpler way, does that also somewhat eliminate the review process?
It doesn't have to, no. Our review
Okay.
process, just like for applications, is completely what the board wants to do in review, so no. I mean, you wouldn't have to review it if you chose not to. But considering that in this program, we allow PDHs for our meetings, for attendance in some seminars, different things, there's a lot of flexibility. I think the statute is definitely, or the rule is broad enough that we could look at different options. Adding a course number would mean that they've sent us everything to our database for your review. But it doesn't have to be the CER number. It could be something much simpler. We could pick the magic date of, even though the year started, starting next month. They're going to send us the information, we create it online, and we give it the number we have and avoid the CER number completely.
Well, there's nothing in our rules that specifically
Absolutely not.
addresses a CER number, and that's part of the reason why I'm asking this question.
Yes.
Because, one of the obstacles that we've faced over the last several months has been, turnover of the courses and when they're approved and things of that nature. So if there's something in your all system that, if we need to give some kind of approval to help simplify, I myself would be all in favor of that. I don't know what about the other members.
I think we would need a motion if we move toward not using the CER numbering system anymore, and we would simply go with what CORE has assigned, and that's unique to everything. And it would take us maybe a month or two to convert the CER numbers to our document to have what CORE has given them, but that's literally, maybe not even that, maybe in a week, we have the current number. And that's it. When individuals are audited, similar to Jay's drawer, they're going to provide a copy of their certificate. It won't make a difference to us if that certificate, when we do the 2019 renewal, has an old CER number versus our core license 175. We will know by the name of the course, who the provider is, that it was legit, that it was approved. And at that point, if we're looking at 1,200 licensees renewing and we pick 10%, the volume of what we are going to have to audit and look at is very manageable. We would bring before the board anything that's questionable. So if someone submits 5 certificates and those courses don't ring a bell, when we look them up by provider, by course name, we can't find them, then at that point, the board's time would be used for that. But if we can identify ourselves, then we would move them and say the audit's complete. You're in compliance. So if you're so inclined and don't see the need for the CER, we would need a motion. I think it'll be an education piece to let those course providers that are used to seeing it just know we've now changed systems, which we have, and we're taking advantage of the system to save staff time and give you the number the system assigns you.
Okay, well, I would like to ask Mario, and the reason I want to ask Mario is because he has worked with CER numbers with TAPS for as long as I can remember. So, I'm glad that you were here to hear the discussion. Would you have any input in that from TAP's perspective, per se?
My only concern is that if you assign a number as it comes in, that doesn't mean it's been approved. Does the person who sent that request in have access to that number? Because if they get a number, they're going to assume that it's been approved, just because they've got an assigned number. You know what I'm saying? So it hasn't come before you or it hasn't come before review. You've just assigned a number to it right away. So does the person who's applying for the I'm going to call it a CER, the person who's applying for that number, do they get that number back from you at any point? And my other question is, why can't this new number just be called a CER number? And
and so the main reason is the system really assigns, just like to your licensee. You don't have LS in front of your license number. You have a license number. It's really just a number. So our system, it was doing the same thing for the courses. Those numbers already exist. They don't say CER because the system doesn't do letters and numbers. So we already know what your TAPS course is. You don't know it, but we do. And so we would release just that number and stick to it and not manually have to follow the CER number. And yes, the person, once it's approved, our system logs them as approved. So you would be able to see it, and if we implement an automatic email to say, here's your license in our system.
My only question is, why can't the number that's being assigned, just for the sake of argument, be called a CER number, even though it's technically not? Just for the continuity purpose.
Yeah, I mean, it could be. It's not going to say it on our documentation anymore. It's not going to be the same number. So CER 1970-18 won't be. It'll be a new number, but you can call it CER and whatever that new number is. And
on the completion certificates, you would need to put the assigned one, not the CER.
Now, you can add the letters if you choose. I think that's what you're wanting to do. You're still wanting to add your own letters, but then it'll be a new number.
Yeah, no, I'm not actually wanting to do anything.
Okay.
I'm just sort of
Yeah,
talking through this.
absolutely.
I think everybody is trying to make it easier on your part, because you've got two different, essentially, numbers.
Correct.
Okay?
That is absolutely
And you're
correct.
trying to cross-reference them to try and figure out whether or not a surveyor's completed a course or not. So that takes time. So my question is, okay, you're throwing CER numbers completely out. They don't exist anymore. And you're assigning a number as a course request comes in. To me, in my mind, that becomes the CER number, whether it's approved or not.
Absolutely.
Yeah. So that's the only number. We're only talking about one number now.
Absolutely.
We're trying not to talk about two numbers.
Absolutely.
Yeah.
That's
So we're
right.
simplifying the process from two numbers to
Absolutely.
one, basically.
But you're asking if the applicant
Has access to that
has
number.
access to that number before it's approved.
Yeah.
So before it's approved, they will once you put it in core, they could, but they won't have access until we approve the course and we release it. And we release the courses, if we go with our system, this manual form on the website that we keep track will change. I will kick out a computerized report of exactly what it is instead of us manually, like this is page 39, revised January 16th, page, not
Oh.
seeing 1 through 38.
So your report would
It's gonna be
probably
automatic.
identify approved, denied,
Absolutely.
or in progress.
Absolutely.
It'll
It
be a
will be
regular
live
report.
from our database. That can be done without much problem. This can't be because our system doesn't know what a CER is. We're manually creating it, hence why we have to literally create this report that you all are used to and looks lovely, but we could make a mistake. We could number the pages wrong, and we did a couple times, so it would definitely simplify it. Once it's approved and denied, the system itself will say approved or denied. It gives you more access to things.
I don't see a problem with that. To the board, I don't see a problem. I do have a question, a follow-up though, about post. If you're applying for credits after a course has been completed. So if I attend a course that has not been approved by the board and I want to put that in because I believe it was worthy.
Don't work that way anymore.
It doesn't work
That's
that way
the problem.
anymore, right.
That's one of the topics that I think we need to educate the licensees on at the conference is it don't work that way anymore. We're in a new world.
Now, your licensees, thinking of from their perspective, I have this one-time opportunity because I'm traveling, I'm in California, and I can take this course and I take it. They could still request, not that we want to do this because you don't pay for this, it's labor-intensive and it involves time for the board, but they could request for an evaluation of that course if they didn't want to wait until they were audited. If they're audited and took it, and in their ethical conscience, it was about surveying, I wouldn't say don't present that. They would present that, and that's the one we would bring before the board. In this audit, one course worth 20 PDHs appears to be, and here's the material, and you'd need the material. I think those are one-offs that you'd have to address if they're audited because they genuinely took a course that they felt was accurate.
Cool out?
You're bringing on fires.
Attention all floors, if the fire alarm goes off, do not evacuate. It is a test.
I done went through that once.
Evacuate.
Today must be firearm.
Yes, we won't share what Mr. Lingerfeld did, ignoring a fire drill before, but anyway.
No, I'm criminal.
Does that help? So I don't think we would discourage people from taking great courses that haven't been approved and don't have, whether we call it a CR number or a core license number. It's if you're audited, present what you need to be evaluated at that time.
They're just taking them at their risk.
They would be.
Basically, and that's what it's going to be.
But that's
and we talked about this before. For example, if you were licensed in Montana, for example, okay, and if you take courses in Montana that are approved by them for their licensure, chances are we would probably approve them. But now we wouldn't approve something that, for example, like Montana Standards of Practice. We wouldn't approve that. But if you took ethics in Montana, we would approve that because ethics is pretty well the same for the most part everywhere, unless there was some issue about the syllabus of the course. But in the new world we're operating in with the audit, it's kind of like going to Vegas. It's kind of like a gambling deal because there's X number and there's only going to be so many pulled out, and those are the ones that's got to step up to the plate and perform. And so here, this is what I did. And these are going to be either good or bad, and if they're bad, then you've got so much time to rectify, so forth and so on.
What I have concern about, and I'm just verbalizing thoughts, and just to see what your reaction is. Let's say, for example, we had a course that was denied here today, a course, hours I think it was completely denied. So let's say a number was appropriated for that, and the person applying for the course saw on the website that they had a number, and that went on their printed list. Because of the timing of the denial, people may sign up for that course thinking that it's an approved course and find out after the fact that it actually had not been approved.
I don't think
The
that-
report won't show
No,
it
it won't show
approved
it.
until it's approved.
Right.
We physically, Jamie Process does a ton of work. She clicks.
That number will not appear anywhere that
That
someone can
number
use.
will
That's
only-
not-
The
Right.
number will appear, wouldn't it?
If they're an applicant in process, we can program the report to not list the number until it's approved or denied.
Right.
And I don't think we necessarily would print the denied other than to let the provider know their course
Right.
is denied. But the applicant, we would just print online, just like these that are online now, it's only the approved. The report would be identical to that. And to just compare for a minute, the Architect and Engineer Board has about 23,000 active licensees compared to our 1,200. So they take the courses, again, on the risk that this is going to count, because I'm also licensed in California, Alaska, and Hawaii. And so when we audit them, they provide their syllabus. It does not go back to our board members unless we have a concern. The office has the leniency, if you will, to look at the course and say, this is about Alaska only, we can't apply it. However, this is ethics, this is general protecting the public. We looked at those standard practice concepts and the material they submit and make that judgment call. This board could do the same or decide when they're audited, if you're in doubt, bring it to us no matter what, but follow these 3 steps if the topics are. Sounds good?
I think we need to have a motion to allow Ms. Roxanne to put our number system in the core system. Now, that's my request to the board, if the board so sees fit.
Make that motion.
We have a motion. Do we have a second?
I'll second.
Any further discussion? If not, all those in favor say aye.
Aye.
Opposed? All right, if it would be okay, if Ms. Roxanne is done with the education report,
Yes, sir.
I'd like to take about a 10-minute break if we could.
Sounds good. Thank you. And thank you for that motion.
Thank you.
Thank you.
Okay, welcome back after that short break, very much needed. I think I would like to, while we're still in the education report, I would like to reopen the last case concerning continuing education. It was some courses provided by Lucas and Company, and see if the board would have a motion about approval.
Mr. Chairman, if I may, I'd like to make a motion to approve those as requested by Lucas and Company as listed. In review of the material he's submitted, I'd like to make that motion for approval.
Second.
Okay, we have a motion and a second. I would like to check the rule just momentarily. What I'm looking for, Miss Ashley, is the half credit hour we had at one point in time statement, and I don't recall if it's still in here or not, about a course having to be even hours. So I have that currently in discussion.
We do have a conversion table in Rule 0820-05-.04. Is that what you're looking for?
I
think that's where it was at before, but again, we changed this, and we had some dialogue prior that was on a half hour, and this is the first one I've seen that has a whole lot of half hours. And I just wanted to make sure, I didn't want to approve something that was contrary to our rule.
What if we whatever the word is, provisionally approve them for 1.5 hours and pending nothing being found by Ashley, they're approved? Can we do that?
I think that's fine. I think it actually was eliminated. Sometimes I have too historical of mind, so I just wanted to double check that, but I think that's perfectly fine. If there's no other discussion, we will go ahead. Well, first off, for Robert's rules, we will need to amend your motion, Mr. Kaufman, to that. Do you agree with that?
Yeah, I agree to the amendment.
And do you agree with the second, Mr. Dilhay? Okay, we will vote now on the amended motion, which allows Miss Ashley to check that out for us. But I think we'll be okay. So, all those in favor?
Aye.
Opposed? Okay. Okay, Ms. Roxanne, back to you.
Thank you, sir. I think if we're back on the agenda, we are now on to the legal report, and that starts on your iPads on page 34, and I will turn it over to Ashley.
So the first item on the legal report today is item number 2018-07-4051. This was an unlicensed complaint. The person has no disability. The complainant alleged the respondent might be engaging in the unlicensed practice of land surveying, and so based on that allegation, the case was sent for an investigation and a review. In response to the investigation, the respondent provided an affidavit and documents explaining what type of work he performs, signed surveys. And then these items were then sent to the expert reviewer, who found that the respondent was not and is not practicing land surveying. The expert reviewer, however, did find an issue with the use of the phrase, quote, property surveys and services, close quote, in the respondent's business name and on the business card, in the use of, quote, as built, close quote, by a third-party website. As for the first item, the business card clearly indicated that the respondent performed signed surveys. And then as for the second item on that, we have no evidence that the respondent controls the terms utilized by a third-party website. Additionally, this pending complaint is not the first complaint that was submitted by the complainant against the respondent. In 2012, the complainant filed a complaint against the respondent, making essentially the same allegations. That complaint was presented in August of 2012. In your report, there is a paragraph of how that was originally presented. And when that was presented to the board, they agreed that the circumstances had been met, and they voted to close the complaint against the respondent. We would again recommend closing the new complaint at issue today.
Okay, does anyone have any discussion?
Well, just briefly, if I may, Mr. Chairman, the issue that concerns me mostly is there, as outlined by the expert reviewer, found an issue with the phrase, and I put in quotations, property surveys and services on the respondent's business name on his business card. Disturbs me a little bit there. The layman and certainly to the professionals and the registrants, what a property survey is a property survey, what it certainly implies, as opposed to the actual business, I think, that the respondent is offering. I wanted to bring that up for discussion here to see if that triggered any red flags with anyone else as well. And the reason I really bring that up is in the update. It says here that that the respondent has agreed to move his advertising, whereby the publication has moved the respondent's advertising away from surveying and move it to signs, but that doesn't address the fact that he is actively advertising property surveys on his business card.
That's correct.
That part was a bit uncomfortable for me. I wanted to bring that up for discussion. First, I wanted to make sure I understood it correctly. Secondly, I would like to review the rule that addresses that in terms of the advertising of the professional service of surveying, and to see if there is a clarification on that. And to take that one step further, I guess I'd like to address with Ms. Ashley. I think you probably see where this question is probably going. As he is not a registrant, a licensed surveyor, what authority does this board have over this respondent in terms of the allegation that he is offering professional surveying services on his business card?
This one was kind of hard because we have to present everything anonymously, and so I couldn't just provide you with what the name on the business card was listed. I will say that the property portion of that quote is really like a title, so it's kind of, it's X property surveys and services. It's like, that's not the whole name of the company.
If I could be generic with it, may I use the word Jones? Mm-hmm. Are you saying it would be Jones Property Surveys? Is that the way is that what's expressed on the card? Or is it Mr. Jones and then underneath Property Surveys and Services?
It's basically like I'll use the example that Roxana just said, like strategic property surveys and services, but that's not there's more after surveys and services. I just can't reveal the whole thing because y'all have to consider it anonymous, if that makes sense. But it does not look, the business card, neither the business card nor it doesn't look like they're trying to say that they do property surveys. That's just the name of their
the reason really that I address this is the fact that our expert reviewer apparently has had an opportunity to review it, and he expressed an issue with it, if I'm reading that correctly. Did find an issue with the use of the phrase, quote, property surveys and services, end quote, in the respondent's business name on his business card.
Well, if I may, Miss Ashley, in 6218-120, subparagraph C, I guess it's C, a person shall be construed to practice or offer to practice land surveying who, by verbal claim, sign, advertisement, letterhead, card, C-A-R-D, or any other way represents the person to be a land surveyor with or without qualifying adjectives, or through the use of some other title implies that the person is a land surveyor.
And I think what she's saying is, based on her interpretation, that card doesn't represent anything there. Correct me if I
that's correct. That's like I said, it's a hard one to present because we do have to present it anonymously. So I can't just provide you with the business card and show that to you.
Right.
I will also say, and it's in the legal report, that both the business card and his website do say signed surveys right underneath the name.
I guess I would have to refer, Ms. Ashley, back to you in terms of a legal sense of what is being implied on the card. Is it in your legal interpretation? In other words, would you have enough there to justify going forward with this with the complaint? Is the implication of being a registered land surveyor there on the card? And really, that's what it boils down to: is does legal have the teeth to go forward with this? If it does, I'd like to pursue it. If not, I understand that the handcuffs that you have on in terms of what you can and cannot reveal. If it's not there, just say it's not there.
I would like to add to that, if he doesn't have a license, and never did, can we even do anything?
Well, that's a whole other topic.
I mean,
that's a whole other topic.
I'm looking at the spirit of, hey, look, we've already smacked you on the hand once with a letter. Wait, let me finish with a letter, and you replied, you being the respondent, replied and said he would comply with the board's laws and rules. The respondent said that to us in 2000. I remember this case in 2012. Okay, so he said, "Hey, look, I didn't mean to do this. I'm sorry, and I didn't realize y'all had all these rules, and now I'm willing to comply. Okay, now, the expert reviewer tells me that possibly he has not complied. I would think that at a minimum, he should get some type of letter of instruction from legal that says, hey, look, you already agreed you're going to apply to things. Now you're using terminology that implies, if you could say that implies that you are still related to this profession.
I would say that, and you're saying that you were here in 2012, so you remember this complaint, so you would probably know this better than I do, because I have to, when I was looking at the 2012 complaint, I just have the information that we still have available on how it was presented in an older legal report. It was not my understanding that the board took issue with the respondent's name at that time. It was that there were third-party websites listing the company under surveying, and that was the issue. And to get into compliance, I believe he reached out to those third parties. Like I think one of them was like Yellow Pages had incorrectly listed him under something else. And so, like I said, the expert reviewer here did find an issue with the phrase included in the business name, but that was the business name before, I believe, and I didn't think the board had an issue, at least as far as I could tell. And then as far as the other part with the use of as-built, that was on a third-party website. The respondent does have a website, and, legal reviewed the website and didn't find that the respondent was holding themselves out to be practicing land surveying or using any of those terms. Like I said, the as-built issue that the expert reviewer found here was on a third-party website, which we have no evidence or indication that the respondent can control what that third-party web on the site.
I understand.
But with that said, if the board wants a letter of instruction, certainly that's up to y'all to decide what you want to do. Like I said, legal's recommendation was to close, but y'all are welcome to and have the authority to change that recommendation as you see fit.
Well, in my opinion, I think he's addressed as best he can. Again, the third-party website, I understand that to some extent is beyond his control. I get that, and I'm comfortable with the way he's responded to that. Again, my primary beef here is, once again, based on the expert reviewers, the use of property surveys and services. And again, you've said there's more to it that you just can't divulge, but what I don't want to give is the implication that to anyone that would receive his card that he can perform a property survey, i.e. a boundary survey, i.e. that he would be a registered surveyor. I'm just uncomfortable with that, and I would suggest that some sort of letter be addressed to the respondent here about, and referring obviously to the rules in terms of what can be done and can't be done in terms of advertising of his services. Really, it's the word property, or the phrase property surveys, that bothers me, and that it implies that he can offer that service, even though he clearly states he's not qualified to do that, nor is he states he's not a registrant. And that this is kind of the second time this issue in the big picture has come up. So that would be my recommendation, to be a letter of instruction, I think would be. What would be the proper letter there?
I just also wanted to point out as well, the respondent's full name is a registered business address with the Secretary of State's office. It's a registered business entity.
It seems like the issue would resolve itself to everyone's satisfaction if he used a synonym to survey instead of the word survey. But since he's going to probably continue to using survey, I understand Jay's hesitation. A letter of instruction may not hurt, but in reality, I'm probably fine with closing it also.
I would think after, second time around, he might get the idea that it might be nice to have a disclaimer on his personal website that says, we do not provide professional land surveying services.
I bet he does.
Yes, it's the card really that I have the issue with, is the business card. But I really think that the message we send out, if we were to close this with no action, I think the message we send out is wrong, that anyone can advertise property surveys and be fine with it. And I definitely don't want to issue that thought. So again, I'm going to again make a suggestion that this board send a action to the respondent.
I'm fine with that.
Just for clarification purposes and addressing the business card itself.
You've seen the business card, correct?
Yes, I have.
Is it, I see where the expert reviewer, in quotation marks, property survey and services, is that taken out of context, the way he looked at it?
Let's just cut to it. Ashley, did you think when you read the card that you were like, this guy's a land surveyor?
I personally did not, no. Again, I will say that the way that the business card is structured is it has the full name of the business entity listed. In the business name of the entity, there is the phrase property surveys and services. However, there is more before it and more after it. I would also say that the business card does specifically say right underneath the full business entity name, nationwide sign surveys, and then goes on to provide the name of the owner and the business address, website, other things that you would typically see on a business card.
Given that this guy is licensed, a letter of instruction does not affect him whatsoever.
He's not.
I know. He's not licensed.
Well,
Yeah.
I'm like Jay, I want to, because this is the second time around, I want to have some type of paper trail that this guy, that we just didn't push it under the rug. First time we smacked him on the hand, and he basically tried to apply, and I think he did. But the second time we just push it under the rug. Okay, then it comes back a third time. I just don't want it to keep coming back, because it is not a stretch, and I could probably get on my phone and go on the internet and find companies in the state of Tennessee that actually do land surveying that say property surveys and services, and have some title in front of that, whatever it may be, 123 or John Doe or whatever. So I still feel like the implication is there, and I realize what Jed said is 100% right, that the guy may just throw the letter in the trash, okay? But I feel like that we have an obligation, as Jay has said, to protect our profession. And the manner that we do that in is sending that letter and putting it in the file.
And I'm not suggesting that he changes company name, if I understand you, changes company name to comply with this. That's not what I'm suggesting. But I think he could, it would be beneficial if he were to put, on the business card of some sort a disclaimer that I am not a registered surveyor, or I'm not offering professional land surveys or anything like that. A disclaimer, I think, if you had told me there was a disclaimer on the card, I'd been fine.
Yeah.
I get it, because that's in his company name. I get it. But without that disclaimer there, it still, to me, implies that he offers property surveys, i.e. a boundary survey.
So I would say that we can send a letter of instruction if that's what the board votes. However, I don't think that there is jurisdiction to specifically instruct this respondent to place a disclaimer on their business card, or change their business name or anything like that.
Suggested?
I would say you are 100% correct, Ashley, and I say we do it anyway. He doesn't know that. We don't have control over him.
Aha, public versus governmental attorney issue.
Let's see.
I like this guy better every day.
He's growing on me.
No, but she's our attorney, so she's going to directly.
She wants to work next week, right, Ashley?
I mean, you're right. We don't have any jurisdiction over him. I say we do it anyway, because if there's no harm to us, there's no harm to him really anyway. It makes us feel better, like we're at least trying to protect who we are.
Right.
I understand your point. I would again state that the board doesn't have jurisdiction here to instruct this respondent to, like I said, put any disclaimer on their business card or change their business name.
Could we
So that's not
advise
something-
or suggest
We can point to
to
the
avoid
statute.
further future issues that he include?
I mean, we've already corresponded with him on behalf of the state of Tennessee. I don't see any harm in corresponding with him further. You're right, we don't have jurisdiction, but I send letters as an attorney to people in other states all the time to try to resolve things for my clients. I don't see any harm in you doing that on our behalf, regardless, and saying, FYI, we are aware of how you are handling your business. We don't love it. We understand that you're not a direct report to us, but we are aware of it, and we would, politely request that you change your practices, or something to that effect.
I'm just trying to keep this thing from coming back, Ashley.
I will tell you too, this was the same complainant as it was in 2012. So
they've
it's not
got
like we
an-
received
yeah.
a new complaint from a new person who's having the same issue. It was the exact same complainant from the last.
I
It's
don't
clear,
think-
yeah.
unless there's malice there, I don't think that we can pick on the same complaint.
Well, and there might be an axe to grind, but I don't know that that's we care at this point. I'm trying to make Jay and Tim happy over here so we can move on to the next item.
I understand.
Okay, you're close.
Here's my main goal. My main concern is the protection of anybody that were to receive that business card at some point to think that his services are including a property/boundary survey when in fact it is not. That is what the card implies. That is what the rule says if it implies a professional surveying service. In my opinion, it does imply that. I understand it's in the name of his company. I'm not asking him to change the name of the company. I'm just requesting that he put a disclaimer. If the disclaimer is on the card that he's not a professional surveyor or something to that effect, I'm fine with it. I'm fine with it. But it implies to the public that he offers a property survey, which implies professional land surveying services. That harms the public. That's my concern. And to any other person out there that may in the future say, hey, I can get away with that, here you go, here's my card. That's my problem.
Let me ask a question, Ashley. Is legal's position that if someone is not licensed, the only recommendation that legal will recommend to us is close and that's it? Because that's okay.
No.
Okay. Because that's what I'm hearing. If we don't have jurisdiction, if someone's not licensed, then we can't send them anything.
Well, so as an example, if someone was engaging in the unlicensed practice of land surveying and going out and actually doing land surveying, that's unlicensed activity, and the board could vote. But like I said, that's just my recommendation was to close this complaint based on the information that I had available to me.
And I'm with you. I'm with you. And I know we're picking on you here, but it sounds like our concern from this end is that while he's not, it doesn't sound like he's doing that. There may be the appearance of that without some sort of $10 disclaimer on the back of the card saying, I am not a licensed land surveyor. Okay? If that is the case, I still think it is well within our abilities and powers, as well as with somebody who was actually doing land surveying and unlicensed, to send them a letter of instruction.
Well, right, yes, the board, as I said before, can send out a letter of instruction. I was just advising the board that as to the particular disclaimer that you were discussing, to add something to the business card or potentially change like the business name so it's not confusing, is not something that we can, is not something that the board has jurisdiction to do. So if that person didn't do that,
We'd have no recourse.
And that, we acknowledge that.
right.
We acknowledge that.
And so what I would say is if the board does want to go with a letter of instruction, that's certainly within your discretion to be able to do. I would ask in the motion that the board specifically address what instruction they want to be given.
Easily done.
Well, I think it's just a matter of a letter of instruction simply stating that this is the second complaint over the same matter, and the dialogue that was used in 2012 has not changed. And the board wants to bring that back to your attention. Because what's said right there is exactly what we said, and that's what we're still trying to say, is, hey, look, don't be doing this.
I'm ready to make a motion. Are we ready to make
Jump
motions on this? Okay. My motion at this point is that we send a letter of instruction to the respondent in this, and I am happy to get with legal, Ashley, myself, to craft the language regarding disclosing that he is not a licensed land surveyor, and disclosing that on his cards to individuals who might be using his services.
Zap him, Ashley.
We can't do that.
Great effort, Jay. Great effort.
All right. Well, somebody help me out here. What can we motion to do?
Jay, make the motion.
I don't know if I can phrase this in terms of a motion, but I'll give it a
No.
try. I would make the motion, we send the respondent a letter of instruction, A, that outlines the rule that we're referring to in terms of the advertising of services. B, that the board has concern over the business card that outlines property surveys and services, and that it may imply to the general public that offers professional land surveying services, and that our suggestion would be to include a disclaimer on the front of the business.
Second.
We have a motion and a second. Is there any further discussion? I will squelch it if there is. No, go ahead. Go ahead. I will squelch it if there is. Miss Ashley's getting nervous. All those in favor? Aye. Opposed? Okay. All right, Miss Ashley. If you can still breathe, you can go to the next one.
All right.
That's good.
Item number 2 is complaint number 2018-078-231. This is a licensee with no disciplinary history. Here we had a complainant that was alleging the respondent prepared a survey which incorrectly included a portion of her property. In response to this allegation, the respondent indicated it was hired by a county planning and engineering department to prepare plans for roadway improvements, which included establishing both the existing and proposed rights-of-way and determining slope easements and temporary construction easements. The respondent found that additional right-of-way was needed on the complainant's track, along with several other properties. The respondent prepared descriptions of the right-of-way and easement acquisitions for each tract and sent that to the county legal department for their use. The respondent believed that the complainant simply did not understand the terminology in the temporary construction easement description and misunderstood the description for a line that leaves one property and runs through her property. This case was sent for review, and the reviewer agreed with the respondent that the complainant simply did not understand the survey or legal description, and the reviewer found no violations of the laws or rules. So legal's recommendation would be to close the complaint.
Okay, we'll bring it back to the board. Any discussion?
Yeah, no discussion. I think it's pretty clear cut. I agree with the staff recommendation to close.
Thank you, Mr. Kaufman. Anybody else? Oh, we have a motion then?
So moved.
Second.
All right, we have a motion to close per staff's recommendation. All in favor?
Aye.
Opposed? Okay, you're on a roll, Miss Ashley.
Item number 3 is complaint number 2018-086611. This is against a licensee with no disciplinary history. The complainant alleged that he contacted the respondent to obtain a copy of a land survey for a house he was buying. Complainant indicated the respondent stated he would look for it and call him back, but never did. The complainant claims he contacted the respondent multiple times over a 3-week period. In response to these allegations, the respondent stated that the complainant contacted his office to obtain a copy of a survey performed in 1985 by another land surveyor from whose wife he had purchased the surveying firm. He told the complainant he would look for the survey but was unable to search for the file as quickly as the complainant was hoping. Additionally, during his search, he discovered the drawing number stated in the deed did not match anything the surveyor did in the county at issue in 1985. Respondent also discovered a tax card for the property indicating a newer survey had been performed and recorded. After researching into this, the respondent was able to locate the survey. He indicated he told the complainant to contact the title company and make them aware of the newer survey. Legal's recommendation would be to close.
Discussion? Entertain a motion?
I move we accept the.
All those in favor?
Aye.
Opposed?
All right, the fourth item on the legal report is a represent. It is complaint number 2018-042-101. This complaint was originally presented at the last meeting, and it was tabled and sent out for expert review. This was a situation where a complainant alleged that the survey they received did not meet the minimum state requirements. The respondent responded to the complaint and stated that he regrettably failed to include several state minimum requirements on the survey and went on to list what the missing requirements were. We sent this to a reviewer who agreed with the complainant that the plat did not meet the minimum state standards. The reviewer noted the same violations that the respondent did. We would recommend letter of warning. And this was a... Oh,
I'm
sorry.
Go ahead. No, go ahead.
I was going to say this was a licensee that did not have a disciplinary history.
Discussion? Questions? Motion?
I'll make the motion to agree with the recommendation from staff for the letter of warning to the respondent.
I'll second.
All those in favor?
Aye.
Opposed? Okay, Miss Ashley.
All right, the final item on the legal report today is a represent of complaint number 2018-035-811. This complaint was originally presented to the board at the July 26, 2018 meeting. I've included in the report a description of how this was presented. The update here is that the respondent passed away on September 6, 2018. On this, legal would recommend closing the complaint.
I have one question about this. Which respondent died? One or two?
It was respondent number one, the one that
Okay.
the board voted to initiate action
Oh, okay.
against.
Gotcha.
I move we accept her recommendation and close.
Second.
Motion is second, and I would certainly like to say that I'm sorry to whoever the respondent's family was. And we lost another licensee, no matter what the situation was. So we have a motion and a second. All those in favor?
Aye.
Opposed? Okay. Close your legal report, short of zapping us.
That is the end of the legal report. Thank you.
Okay. It's 11:21. Miss Roxanne, you want to start your director's report, or?
I think we can get through most of
Okay,
mine,
that's
actually.
fine.
If then the board wants a break for lunch and come back to the new items, that would be great. I'm going to start with, and I just realized, apologizing, the document, the budget starts on page 40 of your iPads. However, I believe that the fiscal note that you're reading, unless they've got the year wrong, and I don't think so, I think I grabbed the previous years, because it clearly says July 2018 fiscal year ending, and it should be 2019. Is that the
Mine
right number,
says
Mark?
begins July 18.
Okay, thank you.
And ends June 19.
Then we're good. I'm in 19 mode, so my brain, so we've got the right one. I was going to say the numbers look right, but that was throwing me off. You're absolutely right, because we've only got numbers through November of 2018. Okay, so that 40,260 that we're in the red is kind of what we expected. We knew that the last 3 months we'd have a little bit more expenses, distribution of some updates to our system. So we're on the last stretch of running into, using the revenue that we carried from the renewal of 2017. I think we'll just continue to see this. We're minimizing expenses as much as possible, as you all know, but I don't see anything really that we would need to address or can cut in any way on these until we get to October. Maybe we can decide if September we release the renewals, but that's kind of where we're at.
Ask one question?
Yes, sir.
Roxana? Could you explain better the Edison expenditures? I've noticed over the last, well, since July of 18 through November of 18, which are listed here, steadily, well, the first 3 months were pretty much even, but then all of a sudden a pretty substantial increase in October of 18, and again, another increase in November of 18. Can you just explain better to what that is?
It will continue to look that high, hopefully not much higher. The cost backs that used to be broken down to include a lot of the administration cost backs that we get were treated separately. They're part of Edison now. So that's where we're seeing a change in that amount. Edison now is including a lot of those customer service pieces that we get charged on and so forth. So they're coming into that line a little bit differently. Edison includes any travel that board members have, but it always has. So the big change is that piece. And Edison also includes computer breakdowns, and so the billing for that I mentioned went up in the last couple of months. The cost back that every program is charged for the system that we use happened to hit us all at once right at about September or October. So that's the increase that you're seeing on the October through Edison.
I noticed the October, November substantially larger than the prior 3 months. Is that something that we can expect to continue at that amount, or is that going to increase or decrease? Do we have
I've been
expectations?
told for all of the programs that should be it, that it should level down. So more things are going through Edison, but the expenses for the computer piece that was significantly bigger those months impacted those 2 months. So that should level off. We've got some extra lines for you to be able to see legal distribution of expenses, for example, item, investigations, that would be the reviews on the complaints, those kind of things. But Edison is where we do your reimbursements, and one of the things that you're going to see a reduction in hopefully soon is actually how each program is charged for rent, if you will, because now that we work 3 days from home, we're moving to the 9th floor. We now work out of crates and plug into different desks. That's going to continue to be that way. We're going to plug in where we arrive. But we'll be on a different floor, and part of this building will change. We're again, being here only 2 days a week versus 5. Saves all the programs some money. I don't think we'll see it in this renewal cycle, but it is long-term going to. So I think when we get to the December and January piece, we should see that expenditure line for Edison level off. And we can talk about, in 2017, I think we opened the renewal in October. So we start seeing it early on, little bit of an impact on the renewal. But we may see more now that the continuing education piece is an audit piece. It doesn't mean they don't do it. It'll be interesting to see what licensees decide to do. If we open it in September, that's the earliest we could open it. Is that going to bring us some money? At the end of the day, it's still, see it early, but it's still the same stretch of money.
My concern really is the bottom line
Yes.
there. When you look at the totals for those first 2 months especially, but the third included, and then compare it to the last two, the expenditures have more than doubled.
Absolutely.
And yet we're still, speak
body.
of staff, making extreme cutbacks. You
Absolutely.
mentioned crates and play.
Yes.
Is there anything really substantial that one item that really has just jumped out over the last couple of months that has really expanded this?
The bill from the system. The update to the system had not been prorated or billed consistently, so when CORE did its last round of changes, we were billed all of a sudden for something that lagged a year and a half or so behind in work.
Is it specific to this board, or is it
Every
across
single program.
all boards?
All boards.
Seeing similar type?
Yes, several that have never been in the red went into the red.
So is it fair to say that the system can actually force the board to increase its fees, whereas the legislature is against that? Is that fair?
I think what we are going to see with us here, Land Surveyor Program, is unfortunately not an increase in licensee pool. So that's gone down. And then expenses, whether it's computer expenses, centralized certain programs, distribution of legal in a different way, maybe not dropping, but definitely staying consistent or going up some. And that is costing us to not have enough in fees to cover the 2 years. I think we're going to, at the end of, when we get ready to renew, we're going to have a very different negative balance than we did 2 years ago.
So I noticed
for both
that,
of those pieces.
I know 2 or 3 things. One, I noticed that in the same month, November of 17, we had a deficit of about $16,000 some dollars. And I also project that if we stayed with the $11,000 per month, 7 months, that's another $80,000 roughly. That would put us at about $120,000 deficit total. But the deficit that we had in 17 was about 112. So ideally, we're not terrible, but it will be more. Now that's just my quick arithmetic and round numbers.
With you. Absolutely.
But that's just that's the thing that I realize the legislature doesn't want us to increase fees, but we do have areas to where potentially other boards charge for certain things that we don't, i.e. continuing education, i.e. firm registration, just a few things that we certainly could create a revenue stream that would not be inappropriate with other boards and practices.
Or states.
Another case too, and not that we want to do this, but if you notice under the top portion for our revenues, we do not, I can't think of the last case where we've charged a civil penalty on a case. So we are not bringing in revenue, and that would be the complaints. That would be that individual that you decide $250. Not to say that you should, but some programs do.
Well, and see that's another area of contention that I've had since I've been on this board. That policy, I think, was written in '94 or something, and it clearly states that it's the civil penalty is to be a monetary punishment, basically, is what it says in my simple terms. And at the rates that are there, it's really not, unless you can really identify days where you can get a multiple. I mean, it's just anyway. Go ahead.
No, so I definitely agree with you, not charging for continuing education evaluations. All those pieces that some other programs have means of bringing in funds, we don't. It's worth us discussing it.
And it's my opinion, and it's not necessarily founded, but I think that if you had a fee in some structure for continuing education, potentially some of the situations that we discuss meeting in and meeting out, we might not have.
Definitely, not every program charges it, but many do. And the material that is provided for land surveyors, as the debates had to go on, it's substantial. It requires our volunteers that look at this, you all that look at it. It is time consuming. There's no doubt about it. So it's worth us thinking about it, maybe as homework kind of information. Ashley would, that would be a rule kind of thing, and we'd have to have that conversation further. But definitely the second time we're talking about our fees going, they're not going to look as good when we end this 2-year cycle. So we'll have to see what that magical number is. You've got on the next page a report for the complaints. This is just our open complaints. I thought again, since our system is giving us, these are Tableau reports, some graphs we can start running. You may see each meeting, I'll present different looks till we get to a good point of what you want to see every time. So these would be every open complaint, if you will. So they obviously are the ones that we've already addressed. But the main reason I wanted you to see it is the aging piece of the cases. So not the very last column, but the second to last, that aging. We are, Ashley, myself, all of us, kind of are tracked by how quickly we can move our items. And so the complaints are tracked based on 180 days, and you want to get them from beginning to end resolved during that time frame. The oldest one we've got down here is 2015, and that's probably waiting for consent order to be signed.
That's Erica's case.
Okay. So I don't have an update right now on that 2015, but it'll probably go to litigation. That's our oldest one. But I wanted to kind of let you see how the numbers look, if you will.
So these are all of these, we have reviewed all of these?
At some point, absolutely. They're
Okay.
all open. And so any new one, I don't see a 2019 case one. But if it's new, you would have reviewed it today. I think the newest is from December the 10th.
So if we send a letter of warning, will it be on here or will it be closed?
It will be on there.
Okay.
So this isn't necessarily, so let's say this December 10th one, which the start date's January 2nd, so legal hasn't even seen this one, or if they have, it says legal case received from staff. They probably just got it. Do you remember if that one was on the meeting?
Which one?
The second to last. It's 2018-0.
I've actually been asked the question by registrants as to how long it takes to process a complaint. And my basic response is it depends upon the complexity of the complaint.
And that is correct. So we track it. It was?
Yeah, we
Yeah.
presented. They closed
Okay. So you presented the second to last one, and we closed it, for example. But back to the timeline, it is on a case-by-case. If it has to go for a reviewer, then obviously that is going to take longer. If we get it and at the meeting the board says, well, we want more information, that's
Right.
going to take longer. We still try to move them within the 180 days no matter what, and some just can't. So this report I will be presenting so you kind of see what's sitting there in the pipeline. Help? Some? Okay. One of the last items that I do have for us to talk about is a PSI quick update. Next week, I believe you all are gathering electronically to develop some questions. Is that
Yes,
correct?
ma'am.
Okay. So, and thank you again to the ones that are participating. This is a huge effort. I have on your iPad some email communication just so we didn't forget to address this. At the last session that the subject matter experts, including Mr. Lingerfeld, discussed was the board allowing them to receive some PDH hour credits for their participation in developing these exam questions. And so that I want to throw out for debate so we can consistently decide if we're approving it, how much. And then Alex Ramirez is our PSI contact person. He'll be able to communicate that to our subject matter experts.
Okay, just to follow up on what Ms. Roxanne has spoken about, we had a webinar last year when we kicked this thing off to go through the existing exam questions and kind of pare those down a little bit. And Ms. Roxanne, and I think it was Sarah, wasn't it?
Correct, yes. We
They
both.
participated as well, and that lasted for 4 hours. And then we had a meeting in October that we actually met with Mr. Ramirez on site in Knoxville. We spent 2 nights there and 2 days. We had 7 hours one day and 5 hours another day. So the committee, which currently is myself, Ashley Rose Nallen, and Matthew Linville, have all participated in all 3 of these activities. And currently there's 16 hours that we have committed to the examination and are getting ready, as Ms. Roxanne said, next Tuesday to have another 4-hour exam writing webinar. So respectfully, I'd like to request the board to at least approve the 16 hours that the exam group has already put into the examination.
Yes, so moved.
We have a motion to approve 16. We have a second. Any further discussion? All those in favor?
Aye.
Okay, and from behalf of the committee members, I certainly appreciate it. And as an update, I can tell you that the examination is getting to where I think that we want it to be. And Mr. Ramirez has done an outstanding job.
That's wonderful. I'm so glad to hear that and that you're happy with that flow. I knew that there'd be a new process with PSI versus different vendors, so I'm really happy to hear that. The last item that I have before our new business, and if it works out before you all head to lunch, starts on page 44. I just randomly picked an example for us to discuss the land surveyors in training piece. This is a an item in our statute that allows us to have somebody ask to become a land surveyor in training. They currently pay a $25 fee to do so. I went ahead and ran a report because these are licensees. You all could request this online anytime as a public records request, and I just thought it was important to still see that we're getting these. I did everyone that has ever gotten this license. It doesn't expire, so you can see that we've got some individuals from 2000 all the way to December 20th of 2018 that have asked for and have this certificate, if you will. Doesn't allow them necessarily to do anything, and the question, as Chairman Lingerfeld and I talked about it, is this even something that makes sense now, given that they can take the fundamentals exam online themselves by register at NCEES and proceeding. So I just want to open it up for conversation. What happened when I saw the paper application is that it was it was just incorrect because they can register themselves, and we do so much paperless that we went ahead and added the link in our core system. So they are applying, and every month just about we've got new applicants. So they're doing it, but obviously there is nothing in the website that stands out for these land surveyors in training. So there we also want to discuss, do we want a quick statement on the website that says land surveyors in training, click here, and it'll put them to the online piece. But that way when you have mentors or supervisors or guiding people, you all, the licensees see it on the website. Currently, it's not there. They still get to it anytime they access core. So just two pieces of conversation to kind of decide how we want to address this, if anything.
Well, a couple of things. One, I'd like to say, just for record, I think we signed, 28 certificates today, Miss Jamie, of new licensees. I'm very proud of that. I was very pleased to see the list that Miss Roxanne provided. We have 80 individuals on this list, and the vast majority of them are Tennesseans, which, those are folks that are in the pipeline in one form or fashion. Now, there's some may have changed professions or whatever, but they have the ability to be in the pipeline for where we're going. Part of the reason for this discussion was I had a young man who works in East Tennessee contact me the other day. He had passed his FS examination, and he said, I can't find an LSIT application on your website. Well, there's not one on our website. And when I queried Miss Roxanne, I found out that you have to go to core.tennessee.gov. Well, I'm not really that familiar with that site, but I did a little looking around, and there is this application that she has here. My concern is it's two or threefold. One is we no longer examine the way we used to. And when I say that, we used to have an application on paper that had to be approved by us, and then we sent that to NCEES and told them that it was okay for John Doe or Susie Q. Public to go take the FS examination. We now no longer do that. Everyone can go on their own and take the test at any time once they've got a high school education, basically. So having said that is, not only do we have 80 folks that we know about here, we have other folks just like this young man that I talked to the other day that are in the pipeline that we don't even know about, and I'd really like to know about them. The mechanism that we have is this application with a $25 fee, which comes from heretofore. So the question, Bodes, is do we just want to put a link on our website with a little brief explanation or whatever it may be, however Ms. Roxanne wants to handle that, to key them into this so that we can get them in our system, because the Chapter 714 allows for the LSIT certification, which by our system, it's really their license number. It's the LSIT number that gets actually their license number if they get to the point of passing their license, just because that's the way the system works. And then the FS is actually what, when they pass it, is what triggers their experience based on which path they're going. But as I read this, again, 714, there's nothing in there that says they have to have the LSIT certification as part of that 5 different licensure paths. So what I want, in my mind, is we just need to be able to kind of keep up with these folks so we know who's in the pipeline. And we have the mechanism, it's just that we need to get it on the website so that it'll work for us.
They're finding it. Like I said, that's the reason I ran the report. I thought, well, what if, in pulling the paper? So they've come in just about every month or every other month. So the question is then the link on the website under forms and downloads, and there's no easy way to describe the website unless we have it up, and I don't, can have a link under forms and downloads as we sort of discussed with Tim. Similar probably to where the paper was, which is not under, it's under the professional licensing information and inquiries, and we just call it, land surveyor in training. I just want to not confuse anyone who thinks, oh, this is it, and I don't need anything. I mean, I had this week, and it's the first time I've had it, someone just send me a question, I just have a question, can I take the FS? And my answer could have just been yes, and click and send, because
Right.
that's the answer, yes, you can. And
Right.
so I did say, yes, let me point you to NCWS, but let me also let you know that if you're interested is in licensure, here are the statutes you're going to need to review in your research. Once you dig in the research, send me any other questions, but the answer is yes, you can take it. And so I don't want to misguide someone thinking that once I've got this certificate, I'm ready to go. Whatever statement you all want, that's how we'll put it in for an easier link. But they're getting there. They're emailing or calling, and so we'll definitely add a link back.
I was just trying to make it one,
Yep.
simpler for them.
Absolutely.
And two, give our board some semblance of what's in the pipeline.
Yep.
Because otherwise, before we knew, when Jamie was bringing us applications and we were doing them one at a time up here, we knew that there was X number of people taking the FS exam. We didn't necessarily know how many why I passed it, but we did know there was X number taken at each meeting that we went through them. And now we have no earthly ideal.
Okay, so that's a whole other story. These in the pipeline, which are 80 potential individuals that have a certificate, that doesn't mean that these have applied to go to the next step.
Right.
We can, so I can run this same report for you all, and I don't even need to list the names. I can give you numbers at every meeting. Here's the number of certificate holders for those in training, and here are those that have applied. So correct me if I'm way off, Jamie, but I think we've got easily 20, 25 in the pipeline for licensure. That's over and above this.
Good.
Now, once we get to, and to fill you all in, so I did mention it to Tim, the WINSEP program, whatever we use, that wasn't great, we'll just leave it at that. That is no longer what we're using to review applications for our 3 licensee members. Hopefully in the next 2 weeks, you will have a link through Jamie to directly access a web browser system, nothing added to your laptop, nothing added to your computer. It is supposed to be, and Jamie's going to be testing it from tomorrow on. But today, I'm sure we're sending engineering applications because we get those, kind of 10, 12 at a time. We're going to be testing those heavily, so that's a great thing. That means that when 2 of you approve, there's nothing, no word, no expiration of your password, none of that. So we are thrilled because those 22 in the pipeline then can be licensed throughout. We don't need to delay them, and we can talk at your piece at the end further on. When do we bring them back to the board besides licensing? But if someone is perfect, yes, license this person. Jamie sends it, I click a button, they've got a license to practice tomorrow. So we'll list you those as well. I'm glad you brought that up. We hadn't discussed that. You're going to see this 80 number, but also how many are applying and in that realm of application. We won't know unless you want us to run this from NCWS and tap into it. We won't know how many have taken the FS and not gotten the certificate in training or applied yet. If you want to know that number, that sort of lives with NCWS, but I don't know that unless they've stated that Tennessee is their address, that we would know those. Does that help?
Yeah.
Okay.
I just think that it's prudent that we just use this as basically a knowledge tool. It's already in our law, and we don't have to change anything other than just tweak the website to make it a little simpler. And obviously, I'm tickled to death that there's 80 people that's found it somewhere or another.
Oh, yeah.
Of course, the ones heretofore probably, 16, I guess it was, from there back would have been paper applications.
Actually, no, even newer. We didn't pull the paper till July or August. That paper LS IT application was still out there. Once we realized it really was wrong, we've got to change the whole process. It might have even been late August.
Yeah, because the original paper basically was asking permission to take the FS exam, was what it was doing.
Yeah.
Now it's more just an information document.
Yes. When you're seeing the application, it's just really information about them. Correct.
Right. And that's, I just feel like that's important to us because with our declining numbers, we at least now can have a feel of kind of, we know that if little Johnny or little Susie passes the FS today, they've got a minimum of 2 years before they're going to become licensed at a minimum, depending on their path. So, but we have that hope that, ever how many of those there are, that hopefully in 2 years we'll be seeing them coming through here again. We'll be signing a certificate for them to put them out here working. So that's very helpful to us.
Thank you.
Have anything else on your report?
I don't. I do want to bring up Mr. Winters just as a quick, and he's welcome to stay the whole meeting, but I believe the Kentucky piece is what you...
Yes, ma'am.
I don't know if we want to have the conversation about the Kentucky change. If you do, it's on page 50 of your iPads. I only added to the board the 2 pages of the large board's newsletter for you to review. If you want to have the conversation, he's welcome to stay after lunch, but if he's needing to head back, that's what he was waiting on to make sure it could be addressed.
Sure. Okay, just for record purposes, the state of Kentucky has decided to no longer provide a state-specific surveying examination, which they had a 3-part exam just like we do. We call ours, of course, the FSPS and TS. So theirs was a KS, basically. So in doing so, they're taking a huge leap. They're the first jurisdictional board under NCAAS to do this. Now, I have been on committees for these exams, participated in other discussions at NCAAS, and one of the directions that I personally have promoted at NCAAS is this very thing. And the reason I promote this is because that I think it puts surveyors in the category of a professional. For example, in the engineering world, once you get your PE, basically it's comedy from wherever, and I don't know if it's the same way in the attorney world or not. I don't know if you're constantly taking tests somewhere else or not. But basically, in the engineering world, what it says is if you're a PE and you come to Tennessee and you're from California, we give you your PE, but you, Mr. Professional or Miss Professional, are responsible to know the laws, rules, and the nuances of this state in order to do your practice, is basically what it says. Now, one thing where Kentucky is different from Tennessee is that Kentucky requires a BS degree for surveying licensure. And that's why I applaud them for what they have done, because it works hand in hand with the basically the model rules and model laws of NCAAS, and it also, by them doing it, directs NCAAS to continue to do what I call strengthen the PS examination. Currently, we're in a task force looking at modularization of the PS examination to accommodate public lands, colonial surveying, etc. So they have kind of stepped outside the box and jumped in to be the first ones to do this. I think that I think they'll be successful with it primarily because of the BS degree requirement. If we were wearing the same shoes that we wore in 2013 when we had a BS requirement that came in 2004, I would be 100% for this and be willing to make a motion for it straight up, just like these folks did. But with the current 5 pass that we have, now obviously the first 3 pass are degreed, but the other 2 pass are not degreed, with the exception of the associate degree, which is just 2 years. At this point in time, I would have difficulty trying to do the same thing that Kentucky did, just simply because of the pass that we have in 714. But that's kind of my nickel on it, and the rest of you guys say whatever you think about it. I know Jay's got something on his mind.
Imagine that. Yeah, I'll tell you, when this first came out, just by the headline alone was somewhat shocking. I didn't know it was even in discussion or thought among any state. Interesting to hear that they're the first ones. And on the surface, I was absolutely opposed to it. Just from the headline alone, I was like, I couldn't believe it. I can't believe what they're doing, et cetera, until I did confirm that they do have the BS requirement, which is substantial. And in my opinion, the whole goal here is to put us on an equal plane in a professional status with the engineers and architects boards in terms of the 4-year degree requirement and the national testing without state specifics. And that's what this does, as best I can read into it. And I have to tend to agree with Tim on his assessment that it's a great idea. I would hope to get there, but I don't know that we're there based on our 5 paths to licensure here. I want people licensed. I want to get as many as we can licensed in the state, but I've got to be able to sleep at night knowing that they're qualified with education and experience. And I don't know that if we were to eliminate this test and keep the same 5 paths that I could do that. If we could get there or go back to where we were, I'd be more inclined to be in favor of it. But at this point, I just don't think we're there. I'd like to be. I think it'd be the right idea. I think it's where we need to get to, but I don't see that we're ready yet.
I'm not sure I'm following you guys in how they relate to one to the other.
Okay.
If a candidate passes the PS, now I agree it probably needs to be strengthened, maybe, as you talked about, and that happens. And we present them with, as I think suggested somewhere, with our standards for Tennessee. It's upon them and their responsibility to practice to within our standards. And if they've passed all the other required exams up to that, I don't know that I see the correlation of
I probably have the least knowledge about all this stuff. But for my 2 cents, when an attorney, you have to get licensed in each state. The laws are very different from state to state. I would assume the surveying regulations and statutes that have to be complied with are generally not as complex as areas of the law, which is a good thing. It sounds like this board is not our position. It's not our job to get us in this position today. It sounds like it's a yay or nay type situation, and it sounds like generally we're thinking nay potentially. As far as going forward, and I'd be interested to hear what our visitor has to say on this, if that's appropriate. But I mean, the path forward, if we say, okay, we have 5 paths, and these will get you licensed in Tennessee, we feel comfortable, it sounds like, that those people have the knowledge and expertise to be land surveyors if they complete those paths. If that is correct, and they are still having to take a national test, it sounds like those in conjunction with each other are appropriate working together to allow them to be surveyors in Tennessee. Could be wrong. Another option would be to grandfather in the people who are in the 5-path process and then go back to, you have to have a BS starting in 2020 and then just taking the national test. Those are just options that come to me off the top of my head. Again, it doesn't sound like we have to make any of those decisions today and probably shouldn't. Other than that, those are the things that come to my mind. If the goal is to get people being surveyors, this sounds like the no-brainer long-term solution.
One of the other things key to this is what NCAAS has really stressed the last 3 years has been mobility. This really helps mobility.
Sure.
Because, like I said, if you get a PE in Tennessee, you can all of a sudden have 49 more. And if you get a surveying license in Kentucky, theoretically you could have 49 more. Obviously, this is going to be a slow process for jurisdictional boards across the United States and through NCAAS. But I think somebody had to be first. Kentucky's structure was set up to where if they were willing to take the risk, then good for them, and we'll see where it goes. We'll see how many other folks kind of jump on the bandwagon and what have you. But like I say, clearly, I think the BS is the key, and obviously, and you're right, Jed, that a law could be crafted and get us back there and sunset these other options and this type of thing. So, that's a good thing. That's a good thing.
Are we allowed to hear from our guest on
Yeah,
this?
sure, if you'd like to speak to it.
You may not want to, but
I don't know that I want to.
you don't have to.
I told Tim when he was standing there a minute ago, I'm kind of mixed on it. I'm kind of like, hey, one less test. I've taken the Kentucky one, but I understand that you probably need the exam because you have to learn the other rules for the other states and show that you know what the state is requiring. I also understand the flip side of it, and this is why I'm mixed. I understand the flip side of it. If I'm going to say I'm a professional and I'm going to come work in that state, I'm going to have to know the regs anyway. It's the same as working in Nashville, Memphis, or Knoxville. They're all different. Everything we have to do for all of them is different. It'll be how it goes. As far as the 5-path tracks that we have, either you think they all get you to the same finish line or they don't. So, and I didn't think about that until you guys were talking about that. You say you're not comfortable with going the no Tennessee specific until yes, but I thought essentially the 5 gets you to the finish. And if it doesn't, what needs to be changed or additional courses need to be added for the
I see what you're saying, and my tendency would be if we think these 5 paths will get you where you need to go, don't eliminate them and just get rid of the state-specific test. Attorneys are very jealous of their profession, and so they want to make you take more tests to come practice in their state. So that may be the position we're in. I have no idea for land surveyors, but I mean, it makes sense if the goal is mobility. Obviously, this is the long-term solution. If the goal is mind your store and your business, status quo is what we want to have. Any other thoughts on that, guys?
I'm just real curious to see if this snowballs. If Kentucky's kind of left on an island and everybody just kind of waits to see what happens, or if other states are going to jump on this and let it go. I'd be very curious to watch this.
Something that sitting there listening to it and thinking about it as we were building up to it was, and I hate to use the word because I said it last time and y'all looked at me wrong. We start chipping away requirements, and then how long before it's, well, really even need that last test? I mean, throw your card out there that says I'm not saying it's going to get there, but it worries me a little bit.
Well, on the opposite side of that, that's just exactly the opposite of what we hear from the legislature. They want us to make it easier and quicker for John and Jane Q. Public to get licensed.
Yeah, and I mean, that's where I'm mixed.
And obviously this would be a step in that direction.
I just worry about other things.
And so at the next regional meeting or a year from now, Tim's talking to some Kentucky person and was like, has the legal portion of your meeting turned into a 4-hour event because all they take is the national test, or is it the exact same? Isn't that the question?
Yeah,
Exactly.
You're right. I mean, that's the key. But if you think about it, I'm going to make a broad statement. Jurisdictional exams in the state of Tennessee in the United States for surveyors are comprised probably anywhere from 60 to 90% rule-specific or law-specific for that jurisdiction. Tennessee's no different. We're in that box, okay? So, on any given weekend, I could give you that 2 weeks before, and you could study it, and basically all we're asking you to do is regurgitate it in an exam. That's all we're asking you to do. So, the point of this is, hey, look, you're a professional. You qualified as a professional, okay? We're going to give you a license. Now, you perform as professional. But now the negative is just exactly what Jed said. Okay, now we've licensed 200 of you, okay? Now we got 145 of you in front of us. We're going through legal cases hour after hour after hour. Guess what? We messed up. And that's what we don't want. So, and who's to say that, the BS is the high water mark that keeps us from having 145 people? In my example, you know what I'm saying? It might not. My thing on this, as Jay was alluding to, our law is very, very similar to North Carolina's licensing law. And North Carolina is another state, like Kentucky, that's very progressive. And I'm really interested to see what they do because they have the same 5 paths that we have, and they're very, very similar. So when I see what the boys over in North Carolina do, that's going to kind of let me know kind of where things are a little better, because I'll guarantee you they're already looking at it. I'm sure this is the hot topic everywhere. It's no different than the Sunset Committee in Texas wanting to eliminate the surveying board in Texas. I mean, that's just something that just happened. And I mean, they've not eliminated it yet, but that's just been approved by their Sunset Committee in Texas. And combine it with the engineers, which they've got like 100,000 engineers in Texas, But they can't keep hurricanes out. I don't understand that.
So we don't need to vote on anything?
No, this is totally discussion.
Okay, gotcha.
Totally,
Gotcha.
very good discussion. Very
Okay.
good discussion. Yeah. Very good.
Anything else from our guest?
No, that's it. I appreciate
Okay.
you guys delaying everything so I can get out of here. I appreciate that. I was just curious if you guys had discussed it or what the feeling was on that. It's going to be interesting to see what happens.
Yeah, we'd like to hear a response from TAPS as well. If you could, spread the word and kind of get their opinion maybe at the next board meeting here.
I already got several calls.
Remember
Does that mean I just go apply? I said, I guess so, from what it's saying.
That's right,
what it is.
but you better be qualified under their
Oh, yeah, you'd have
under
you
their
can't get in
reg.
there if
Yeah,
you don't, but
yeah.
yeah. So,
Yeah.
appreciate it. Thank you.
Okay, thank you very much.
If the board is inclined to break for lunch, it is exactly noon. We couldn't have timed that better if we tried.
12:04, but we're good.
Okay.
Let's
And then
break.
when we come back, we will review all the new items, and some of them we might have touched on. And then for applications, we have a total of 5 that the board will be reviewing. So we will break.
What about 1:15 maybe? That'd be okay? We'll try 1:15, how's that?
I'm going with you guys this time.
All
I don't
right.
want to be late again like last time. Coming back.
Tim, do you mean 2:15?
10% of everybody that's paid and renewed, and of the 10%, I only want odd-numbered licenses. So if your license ends in a 3, 5, you're going to be picked possibly in the 10%. That way, the following 2 years, you won't be. It'll be the even. That's an easy scribe, an easy statement for the program to do. Then you won't be back-to-back picked. You might be then the following one, but by then, it's, 6 years later?
This sounds like a stretch, I guess, but you know me, I always have weird ideals. What if you did an audit in each year of the 2-year cycle?
Problem with that is that with our statute as it is right now, they don't have to complete it every year. They don't have to do 15 credit hours each year anymore.
But no, you're not. But what I'm saying is you're not auditing. In other words, if you audited in 2020, you're still auditing the period from 18 through 19. You're not auditing 19.
Okay.
You see what I'm getting at?
Yes. Then for that person that did nothing, you've given them one more year to work
Yeah.
without any CE.
Well, like I say, it's
potentially.
just a question.
Yeah.
Yeah. And you're right.
I would say we nip it in the bud, we get everybody picked that's paid and renewed, and we run it, and then we deal with the compliance piece all at one chunk to kind of get a feeling. This didn't go well, we just opened 25 complaints, which would be a huge number given our numbers, right? For other programs, it wouldn't be. Or maybe we ended up with 2. That would be not a bad thing. So if we do it all together, I think we can have a good feeling right shortly after that renewal cycle.
So when would you think the optimum time to pull the trigger would be on the audit?
I would say no later than March, because by then you have had an entire 3 months after the deadline to renew. Because keep in mind, and we did that this year in 2017, we sent out email reminders. We sent out, I think, 3 to be exact. We did 1 mailing, and then prior to this December, we actually called everyone that we mailed letters to, and Jamie had to work very closely with, I think we had 25 or so that had paid but not done all the pieces. So not looking at that last group that comes a year later, I think if we do it March or so, we've gotten at least 85% done. And we can then do, for those that are lingering during the year, we can do another audit in June or July.
All right, what about this thought? I think that and I'm just going to say that, I don't mean this disrespectful, I'm just what's on my mind. I think that by delaying the process until March, we continually to babysit a small group. Now, it's my notion that we would stipulate, and I'm just going to throw this out, that we would stipulate that all renewals are complete by December 31st, and then we only give a 15-day grace period to January 15th. And if you have not renewed, in other words, if everything is not in order by January 15th, you are automatic audit, and the audit pool is selected. For example, let's say there's 10 of those people that fit in that box that didn't renew by the 15th, okay?
A lot more.
All right. Well, let's just say there's 10. What I'm saying is, let's stop babysitting. And I mean, look, I look at it this way. We've eliminated a lot of this paper process. We've eliminated a 100% audit. So let's stop babysitting the surveyors and let them perform to what the law says. Tell them when we go to the meeting that they've got to perform. And if they don't conform, because other jurisdictions, and I went through pretty detailed, I sent you the audit results and stuff, and I talked to some of those MBAs. If they, in some of these other jurisdictions, if they don't renew on the date that they renew, they automatically go to audit, automatically in some of those other states. So, like I say, I realize that sounds tough, but it's no tougher on any of us sitting here that are licensed surveyors to have all of our stuff in by December the 31st. Why should I get special treatment if I decide to send mine in on January the 30th? Because under the law, as I read it, and I'm not very smart, you're not a licensed surveyor if you've not completed what it says by December the 31st. So why should we continue to babysit and handhold these people? And I'm sorry I'm on my soapbox today, but I just think that if we're going to make this change, and in my mind it's a very positive change for the licensee, all we're asking them to do is one thing, fill out one form and send one check or credit card over the internet. That's all we're asking them to do. Now, if they can't do that, they need a jeopardy. And that jeopardy shouldn't happen in January or March. It should happen somewhere before.
So I think, at least from the renewals that I approved for 2017, those that lingered a little bit behind generally had to do with continuing education. They didn't finish, so they waited till January, maybe February, and then added it in. This is no different. You're not going to add in the document necessarily. And unless we go to as of January 1st, you must put it in the system. Then they're still delaying renewing because they don't want to attest and lie. So they're still delaying possibly for the same reason. So we definitely can draw the line on January 15th and say if you didn't do it, you're an automatic audit. That means that we will have finished the audit. And everybody that paid by a certain date, send out those letters, get that done. And then the next batch, we probably only want to do them in a month to 2 months' time, just because the system needs begin and end date for the payments. It's not quite as simple. If we do them all together, it's very simple. Show us who paid, and then you draw the line. But if the board wants to go with that, we can. We'd have to stop some automatic processes. For example, once we make the change, the system is going to let you finish and pay without attaching any documents, because in essence, we're telling you don't need to. If we change it and they go back online February 1st, it's going to require you to drop them. Otherwise, Jamie will be calling and emailing everyone saying,
I don't want that.
Yeah. But that's the piece. If we draw the line and tell them that they are automatically needing to add CE after a certain date, then we have to force the system to require something and make a change.
Well, see, I mean, all of us remember when Donna was here, and that was one of her biggest tasks, was starting in about October, calling everybody and then dealing with them to make sure they got everything in and hold their hand all the way through. Well, we're totally getting away from all this, and I realize that that's probably a very unpopular, dramatic step, but I can tell you this, in the state of Virginia where I'm licensed, that if you miss a certain date, are no longer licensed and you have to re-examine, start from scratch. period. Period. It don't matter how long you use a license there. So, you know, that other jurisdictions have got some pretty good teeth. And you know, I'm not trying to make it hard on a licensee, because I'm not asking any licensee to do anything different than what I have to do as a licensee. And I expect the jeopardy if I don't perform. And they should expect the same thing. And I just don't feel like that we should continue hand-holding. And if we put the word out that that's the way it's going to be, then that's the way it's going to be. So, I mean, you know, if we decide to audit 10% and that's 110 people or whatever, and there's 50 people that don't perform, then we audit 160 people then. That's just the way I look at it. And I mean, the board may not agree with my thought, but I mean, that's where I'm at. I just, you know, I don't think it's right for your staff, you, Jamie, whomever, to have to continue emailing, calling, hand-holding, whatever it is. I just don't think that's right in the environment that we're in, because our law has been the same for many years.
But remember, one of the reasons that we did what I call them courtesy reminders is to avoid those that didn't get the renewal notice or forgot that they had to do this, didn't do it.
I have issue with that.
So we took advantage of technology to kind of help us with that, because we can without a large effort on our part.
But I still have issue with that
I
because
couldn't agree with you more.
The law says that the registrant is responsible to renew their license before December 31st of every odd year. It's the registrant's responsibility. It's not this board and the board staff to handhold to force them to do that.
I agree. So before the TAPS meeting, I think we need to have probably that decision made. The audit can be 10%. So the question is, does the board want us to audit January 1st? That's the cutoff. Anybody that hasn't paid by January 1st, we run the reports, we get it done, and so we start communicating. Even the piece when you renew timely in October, we can have it say, if you don't complete the renewal, you only have prior to January 1st to do this, or you're an automatic audit, because some people can get in and stop and go, oh, I'm about to attest and I didn't finish my C. We can put that reminder out there. That decision would need to be made so we don't miscommunicate, because we will have a large audience and we'll be able to say, you all knew that by January 2nd, when you renewed online, you were going to be an automatic audit, and we do it February, March, we do them every month.
And I'm going to step off the soapbox and let Jay and Jackie talk.
Just quick thoughts. I'm not disagreeing with any aspect of that. I'm comfortable with the 10% audit to start with. I think, and I hope that after we run it through a few cycles, that based on the results, hopefully maybe we can filter that down to 5 in the future, just because everybody's behaving themselves and doing what they're supposed to be doing. So I'm good with that part. The automatic audit as of January 1st, a lot of me says in a practical sense that he's absolutely right. I'm a professional. I'm responsible for my own license, and that's what the rules say. That's what I should comply. And by golly, it's January 1st. I should be, have to suffer the consequences of not having done what I should have done. But the other side of it is, the end of the year always gets a lot of people because it's the end of the year and the holidays, et cetera, all that, all compounded. And Tim's point of view has a good point, and I don't disagree with it, is January 1st. And there are always extenuating circumstances of somebody out there, hospital issues, whatever. You name it, I'm sure we've all seen them 100 times before. So, a part of me does allow, in my conscious mind, for a little bit of, I don't know if leniency is the right word, but in grace period, it seems awfully soft. That if we were to allow something, I wouldn't want to go beyond 2 weeks, because all of a sudden, sometimes January 1st just sneaks up on you and bam, it gets you, and then you're like, oh, and then it's too late, and then you're almost afraid to submit because now you know you're late. You know you're late, and you're afraid to submit because now you know you're going to get audited. I'm not saying it's a bad thing, and you know you're going to have to, if there are some errors or omissions in there, that you're going to suffer the consequences. And I want to strongly enforce those consequences that are there. But I do think that there should be a bit of allowance for those kind of issues that do hit anybody. They hit anybody, for whatever reason.
I think I said January 1st. I was thinking January 31st, giving them more than 2 weeks. But again, that magical date is up to you all. But
I'm more comfortable with a 2-week barrier, because by then it's hit you, you know it. How many did we see that came in front of us here in the last couple of meetings that they just forgot, whatever.
Isn't there a provision now for a grace period?
No.
I don't believe there
not
is.
to work, not if you didn't get your CE. Now, you don't have to retest and reapply for an entire year, so they've got until the December that just passed to still provide the rest of the
$20
documents.
per month late fee if you don't pay your fee,
Correct.
okay?
That's about all we got. And it
But the
doesn't-
continuing education has to be met. Now, let's think about this just a second. The only thing we're asking a register to do now is to attest on a piece of paper that they got their continuing education and pay their fee. That's all we're asking them to do. We're not asking them to submit any other paperwork.
True, you don't have to dig through the
Nothing.
drawers.
No,
you don't have to find
get Jay's
copies.
drawer,
You don't have
nothing.
to call TAPS and get a copy. You don't
Right,
have to do any
nothing.
of that anymore.
I mean, that's all you're doing. I mean, for me in North Carolina, for example, they send out a little card, and I mark in the blocks and put in my hours and so forth and so on and sign it, and I put my check with it and I put it in an envelope. That's all there is to it. I mean, and that's what I'm saying is this process now is getting to where it is so simple that anybody can do it. And I know if I can figure it out, there's a whole lot more people smarter than I am that can do it.
Sounds like a Geico commercial.
Yeah, that's right.
But then I agree with Jay, 2 weeks would be max.
Yeah, that's my point, is 2 weeks max. And even then, I think, I'm not disagreeing with Tim at all. But I do think that there has to be, because there's going to be those ones that by rather no fault of their own or by, it's just, life happens, that this would just be another compounding thing on top of whatever issues they're having in their personal life, to not allow a little bit of a grace period. And by little bit, I mean no more than 2 weeks, because I think that's a substantial amount of time to say, you're back in the groove, you're back at work, the first of the year is going, you're there, and there's something that just cleared up. But
Okay.
Can I say something?
Jump on in there, Jim.
I like that Tim sees everything in black and white. I appreciate that. I understand that. So as attorneys, to use this example ongoing and probably forever, we have a board that actually keeps track of this. Continuing Legal Education Board, somewhere probably within a block of this building. And all they do is tabulate your hours, and you have to, they keep track of it. You don't keep track of your own. If you apply for an extension, you get a 6-month extension, not just 2 weeks if you don't complete your hours. I understand what land surveyors have to do is a whole lot easier than what we have to do, which is actually go and get hours instead of just sign a form and send it in. But 2 weeks is not very much time. I would say a month at least.
But
in my
here's
opinion.
my argument to that, Jed. You have had from January the 1st, 2018 to December the 31st, 2019, you have had 2 complete calendar years to perform. And now you're saying 2 weeks is too short? I don't. That's where I don't get it. If you only had 30 days to perform, yeah, I agree with you. But you had 2 years to perform.
And you're right. And here's why it's simple for you.
Okay.
Because look, you're well dressed. You do a good job. You probably mind your own business and are a successful land surveyor. But lots of the people you're dealing with do not think the same way that we think.
I understand, and that's fair. I mean, but that's fair. But the point I'm making is, you acclimate people to how the rules of the road are, and generally speaking, the vast majority will conform. And when our rules say that in the biennial period you need 30 hours made up of this, that means any minute in that period you can get that. I'm not very forgiving when you want to extend that period of time after 2 years that you've already had the opportunity to get it.
And I understand that, but we all know people who are going to wait to the last minute regardless, and to just put them on 2 weeks, I understand black and white, and I live that way as well, but that seems pretty heavy-handed to only give 2 weeks.
And during that 2 weeks, can they practice? Because technically, they're not licensed.
Not supposed to. Not supposed to.
That's the whole point. That's the whole point of it is, they're probably going to practice, and I give my court example like I have for 1,000 times. Miss Roxanne's tired of hearing it. If I'm called to court and I have not renewed my continuing education, I am not a licensed land surveyor in the state of Tennessee in the month of January, and the attorney asked me, and I tell him that I am, and he's been to the board site and seen that I'm not, I just lost my case, even if I could have won it. So, again, there's professional jeopardy to it, as you will understand, Jed, but, I'm sorry that I'm taking a hard line on this. But I think that 2 years is plenty enough time to notify anybody that they've got to have 30 hours without continually dragging it on. And I still contend that we should be very emphatic with our registrants so that they understand that if they do not complete the attestation form for the continuing education as of 12 midnight on December 31st, 2019, they are not a licensed surveyor in the state of Tennessee until it is properly completed. Period. Which means they cannot practice.
Let's hear from our guest.
Thank you for asking. I have to disagree with you about the simplicity of things, because if we're asking them to complete continuing education, we have to go and get that education. Whether we fill out the form or if we didn't complete the attest form that says we did. I have to agree with Tim on this particular thing. And Jay, I think the period and the thing that we're looking for is probably there are individuals that you need to show compassion to because there are circumstances where medical issues come into play and that kind of thing. So, I'm understanding of that. But I have to agree with Tim. I'm a professional. You licensed me to be a professional. You licensed me to stand up for what the law says, and I am expected to adhere to that law. And if that law says I have to turn in my hours or attest to the fact that I've taken those hours by that time, as far as a 2-week period is concerned, okay, I don't mind the notification, but even at that, I have known for 2 years I needed to go and get those continuing hours. I don't know how many hours you as an attorney have to get. So
Same as you. 15 hours a year.
Yeah.
And it's yearly. Look, what y'all are saying makes sense, and I get my hours done every year, but there are many attorneys who need that 6-month extension, and they're still pushing up against it. And they live in the world of laws and being a professional.
Yes.
And they need that time. So I get it being a black and white issue for you guys, that I'm not going to raise a big stink, but I just know the world I live in, there are extenuating circumstances. People need more time. 2 weeks is, what's going on in January 1 to January 15th? Probably still holiday time to some degree. Yeah, so.
But in all due respect, all of the comments that have been made, I really do think that no later than January the 31st is probably a reasonable time. I still like the 2-week time, but still, there we have extenuating circumstances. And I do think, too, like Tim, if you haven't met that by December 31st of the renewal time, then from that point until you have completed what is required by audit, you're practicing without a license.
I think we promote that by giving, because you're going to if you're standing in front of the group and you make this statement, you have to have all this stuff turned in, but we're going to give you a grace period of January 31st. What did you just tell them? Don't worry about sending it in December. Just send it in January. It's fine.
So remember, the grace period is actually in the statute. They've got an entire year to take their CE.
To complete it?
They do.
Not after.
They've got until the end of 20. the opposite year of renewal to complete the renewal process. They've got that leniency till the end of this year that we just finished. To complete it, they pay the penalty, and they have to submit it. So that doesn't mean
Show me that one on
Well, it
the
doesn't
continuing
mean take the-
education.
take
I agree
the-
with you on the money.
Okay, it doesn't mean take the course in October, it just means submit everything to complete the renewal, right? But many of our licensees that have renewed after December 31st of 2017 were running late because they weren't working, but they were still taking their CE, so they can't work.
Where does it say, no disrespect, but where does it say in the continuing education that you have a year beyond the renewal as a grace period?
The statute is Tennessee Code Annotated 6218 on expiration and renewal notice and fees. Specifically,
Okay, stop right there, please. You said fees. I'm talking about continuing education. I did not talk about fees. We don't disagree there.
That statute isn't just about fees. I was just reading the title of the statute,
Okay.
which includes fees in the statute, but specifically, item number C of 6218-114 provides certificates of registration shall be subject to late renewal for a period of 1 year following their expiration date by payment of the renewal fee, plus a penalty in an amount set by the board for each month or fraction of a month that elapses before payment is received. Any person whose registration has expired for more than 1 year shall make application for registration, provided that the board may, in its discretion, waive any further examination of such applicant.
I have never questioned that in my discussion because that deals with money. That's $20 a month for every month for 12 months that you have not paid your fee, payment of fee. But in the continuing education rules, under 0820-5-.03, it says that a registrant seeking biennial renewal, okay, you're seeking your renewal of active registration must, as a prerequisite renewal, submit satisfactory evidence to the board of having obtained 30 hours PDH, which now is going to be the attestation, okay? For during obtained 30 hours during the 2-year period immediately preceding application for renewal hours, which that means prior to December 31st, 2019 in this example. Continuing education rule is written different than the fee rule.
From the statute.
From the statute. And I wrote it, and that's why I'm sticking to it. And that's the truth, Jim.
I believe you.
That's the truth.
So the question is...
I knew what I wrote. I knew what I wrote, and there was purpose behind what I wrote.
Okay, so what are we deciding? Are we deciding anything? Okay.
So the question is, if they took the CE but failed to have their certificates and to provide them, these are what we call our lingerers, they paid, but they also took it, they're just not providing it yet. They're still then open for a year.
They're not licensed.
No, but they've taken it. They just haven't sent it to us
Doesn't
until
matter.
the end of.
It doesn't matter. If they have not attested by December 31st, 2019, in our example, they are no longer licensed after midnight. That's what the statute says. Or the rule, I'm sorry. Thank you, Jeff. The moral of the story is you do much better attesting that you had your continuing education and not pay your fee and pay your fee anytime within the next 12 months. Mm-hmm. That's what the law allows.
It allows for it.
That's exactly right. And it shouldn't, but it does.
If you neither submit either a test or
Is what causes you to be unlicensed.
Right.
Right. That's the whole point.
I have a question. Let's say that you get to the end of the period and you fill out your form and you attest to the fact that you have completed your continuing ed. And you pay your fees. But the audit finds that you are delinquent in your continuing ed. Then at what time is he unlicensed at the date of that audit until he completes the continuing ed?
I would think until he completed the continuing ed. Be
From
my
that date
gut
forward?
reaction, yeah.
Okay,
Be my gut reaction.
okay.
That from that, in other words, if you were audited April the 1st and you were found deficient, you'd be given, say, 60 days or something, 45 days or some period of time to get your continuing education.
I think that's where Jeb was saying that the attorneys have 6 months, whereas
Yeah.
we might give them some.
Well, we hadn't got to that yet.
Yeah,
We've not even
that's
got
right.
there,
We're not
but we're
even at
going
that
there.
yet.
We ain't got there yet.
Yes.
In our debates. It's the difference of how it's broken out. You have the statute clearly giving an extra year.
The dollars.
But it says certification, to recertify, to renew your certification. It doesn't say, go refer back to the rule for the continuing education. It really
Or
is
does the continuing
certification.
education rule refer you to that for clarification? It works both ways.
Well, I don't know if we're going to get anywhere
Yeah.
debating that point.
Correct.
What do we need to discuss that would be, is there an action item out of this that we need to discuss or no?
Yes, we need
Okay.
a date, a magical date, because in
Magical
March,
date.
we'll be communicating that to our licensees, right?
And the option is 2 weeks or what? Or that's it?
Roxanne mentioned 30 days or 31
Okay.
days, so I mean, that's, you know.
I probably would suggest the 30, but I'm not going to.
What do you think, Jay?
2 weeks difference.
Well, in discussion, there was some mention of, the first 2 weeks is pretty much a lot like Christmas, and it can be a challenge to find available PDHs in those 2 weeks. So I'm flexible enough to go to January 31st. Yeah. I don't think we're going to get this one to sway, though.
No, seriously.
I'd be disappointed if he did sway.
Seriously.
Just kick him off.
The bottom line is, we need a date to tell the people at TAPS.
We do.
That if for some unforeseen reason, some circumstance comes up or whatever, and you have not completed your obligation that was supposed to have been done by December the 31st,
Yep.
on this date, so be it January 31st, on this date, you will be
Audited.
automatically audited, period.
And you cannot practice from January 1 through January 30.
Well, that's the statute. They shouldn't have been able to anyway, so we.
That should be
I know,
emphasized.
But that should be
Be
emphasized.
emphasized.
That's a very important part that the registrants don't understand. They think that, and the reason they don't understand, that's the whole point of this whole discussion, is that we've babysit them and held at their hands for so doggone long, because that was the way it was changing, and I want to make sure that they understand the rules of the road are the same, have still been the same, but we're implementing them different now, and we're stopping this hand-holding. That's the bottom line.
And we have no problem in it. We've made a note, because I've made it before with previous legal counsel. I just think the statute that refers to the penalty and the renewal of certification is very clear, and it does address the $20. But the rule that talks about C is in a different place, and you don't always sit down with both pages side by side.
understand.
So because of that, even in my mind, and because we have the calls consistently, we hear that confusion,
And
okay?
if you recall, it's been about 5 meetings ago, we discussed this very fact, and I brought up the point that our penalty should be changed, and the time that it's involved when it should be shortened, and we should include continuing education with it, so that we have an inclusive, one thing that we look at, not two things, and to be inclusive so that we could wrap our arms around it, and then it was crystal clear to any registrant, because we told them all in one place. And you're exactly right. It is confusing. I don't discount that. But until we can change 6218-114, until we can change that, then we're going to maintain this confusion.
We're going with the explanation that December 31st is obviously D-Day and when they're supposed to renew. If for some reason they have not, the audit
They have not
attested and completed the
Right.
renewal cycle, then after January 31st, 100% of the licensees renewing will be audited. Point blank. We're good.
Along with the 10% that are scheduled for audit.
Oh, yeah,
Random
but
10%.
our goal is going to actually audit the 10% in January, get them done. And then anybody between January 1st and January 31st and moving forward will be an automatic. We're going to have to change our system online on that day, which may or may not be easy, but we're going to program it from the time we release that renewal notice till January 31st to let you renew not submitting the paperwork. Anything as of January 31st, you're going to be stopped. It's going to demand that you add your documents, and we'll have to add that note. I think we're good after
And
the debate.
that way, when we get to the April meeting, we should have the conclusion of the audit, with the exception of these random people that we can't do a lot about anyway, and we can act on anybody we need to act on.
I don't think we need a motion or a vote because at this point, we haven't started the renewal process. I think we did vote to do the audit. That you all
Yes.
have given us
Yes, we
permission.
did.
These are just magical deadlines for our processes that you've agreed to.
These
and
are important
we can
factors in
share.
it, right.
Yeah, because we'll share at the meeting. And at this meeting, they may have some things we haven't thought of, and the board is willing to discuss and change. So we have time. I think that's a good thing.
But I think we needed to have that much
Okay.
rules of the road in order to provide some guidance or potential direction to the registrants at the meeting.
Thank you.
Okay.
Negotiation there. Good negotiation.
Good negotiation. We had our mediator here, Mr. Northcutt.
That's right. Well done.
Okay. Next item on the agenda is board representative to NCWS President's Assembly in February. That will be held the 7th through the 9th in Atlanta. It's also for MBAs and board chairs. I've been invited to go, so I'm going to go if you all approve it. Here's your chance, Jed. You shoot me right down. I guess we need a motion for that.
So moved.
Second.
All those in favor?
Aye.
Okay, thank you. Okay, next item on the list is approval of exam committee PDHs, which that's our advisory board, basically.
Okay.
That's the advisory board. No, I'm sorry. We've already approved the exam committee. We already approved that one. Okay.
Yes, sir.
Okay. And for your edification, Ms. Roxanne, Mr. Kaufman is going to seek out hopefully another representative for the continuing education group.
Thank you.
From West Tennessee, yes.
Yeah.
I'll be
Thank you.
doing that.
Thank you very much.
That'll give us one pretty
I'll get you
well
a
in
name.
all the areas. If anybody else wants to volunteer. Okay, all right, the next item is State Plane Coordinates 2022, and I'm going to let Mr. Kaufman speak it on. He's got it laying right here, and he's ready and raring to go. Y'all heard enough
Sure,
from me.
this is, and I addressed it, I touched on it earlier with Mr. Winter about asking for a little bit of help from TAPS on this. This is a new horizontal plane coordinate system that's being introduced from the NGS, and it will be over the continental United States, I assume with Alaska and Hawaii as well. That will be going into effect in 2022. And while not getting into any technical aspects of it, what I'm really after here is trying to get some advanced homework done that we're going to need to address prior to this going into effect in 2022. And it really is just I don't know if I want to call it, I don't want to simplify it too much, but a formality of some aspect to where there is a legislative representation that a official coordinate system for the state of Tennessee. Currently it stands at NAT 83, which is the current NGS datum. But being the NGS is changing that horizontal datum, the states, obviously Tennessee inclusive, but all states are being asked to legislatively change their official datum to what NGS is going to represent, that being the 2022 system. So what I've done through Mr. Winter there and with some other contacts in TAPS is I'm asking them to sponsor or find a sponsor for the legislative action needed to kind of logistically change this. Again, I don't think there's much argument behind it. I can't imagine that there would be, but it is something, a little technical process they're going to have to follow through. The best process that I would suggest is through a large professional organization such as TAPS. Perhaps they could team up with somebody like TDOT, other groups of large entities that involve surveyors and work on these datums to be the sponsors and push this through the legislature. Again, it should be a consent item type agenda for the legislature to handle, but it does need to find a sponsor and to get pushed through as quickly as we can. With the board's permission, I would like to probably make a more formal presentation in front of TAPS, which I'd be glad to do, addressing this issue, requesting their sponsorship, perhaps outreaching to TDOT, and to get this pushed through. TAPS does have a lobbyist that they use for their organization. Perhaps they could use those resources to find a legislator to push this through. But again, it should just be more of a technical aspect, consent agenda type thing. I just wanted to bring that up to the board, see if there's any suggestions, recommendations, or objections to me bringing this formally in front of TAPS and requesting their assistance on it.
I think it'll be great, Jay. Miss Ashley, for you, this is 66.6, 101 through 106. It's a Tennessee coordinate system. The last time that it was changed was in 1991. And it's a very, very short chapter. It's very straightforward. Not only will TAPS be involved and TDOT, but I think you'll find that your property assessors will be involved with it. Folks that use GIS. It's a statewide coordinate system that affects a lot of different entities. There's a lot of players in this, but with NGS, a national federal organization handling this, they're basically doing all the heavy lifting and providing all the change information and so forth. And I'm sure that they'll have some dialogue of some recommended language for some of these changes, because I think if you went from jurisdiction to jurisdiction, you would find a very similar law in each one of them, but it would speak to more specifically their particular jurisdiction, because there's different types of systems within this that a state deals with, Lambert, Traverse, Mercator, so forth and so on. So there's other things there, but I just wanted to alert you to that particular law, so that you would be aware of that in our discussion if you wanted to look at it or whatever. It's very, from your perspective and mine, it'd be very minute to you, but it's something that's pretty major to us, because it's kind of like relocating things from here to over here, because they're using different numbers. But they're using different numbers on purpose so that we can coordinate these old numbers with the new numbers so they'll all match up together. So if that makes any sense.
She got that. Even I'm confused.
Jay, I just wanted to admit, well, you probably already know this, but on page 55 of this, it says we're supposed to respond by December 31, 2019. Okay. All right. Just so I didn't know when you were going to present to TAPS, but all right, cool.
Okay. Does anybody else have anything else that they want to discuss under new business?
So are we set?
Random from NCWS on here that hadn't been discussed.
Just the President's Assembly, but have we already voted on the NCWS first meeting? I think it's the August. Do we need to go ahead
No,
and
the
do
May
that?
meeting in Boise.
May meeting. Oh, the Southern Zone.
Yeah, we actually do need to vote on the Southern
Okay.
Zone
I think
meeting.
that's what this is addressing.
Let's see. Board member. Yeah, the Southern was, okay. From May 16th to the 18th, the Southern/Western Zone interim meeting will be held in Boise, Idaho. And we'll be able to send, should be able to send 3 folks, I think, isn't it?
Yes.
Not including me.
Okay, I was gonna say,
Because I'm
not
an officer, a zone officer, they got me, so we'll be able to send 3, so. Probably Jay and Jackie, and now he could go as a new member,
Certainly could.
and.
If you could.
Yeah.
In addition.
In addition, if he wanted to go.
And take any from across the way over here with you?
Well, Miss Roxanne will go.
Okay.
I don't know if Miss Ashley will or not, I don't know. We
When
usually end up having to pay for one or the other or both.
When is it scheduled for? August when?
May
this is
the
May.
Oh, May.
16th through the 18th. Yeah.
So it is possible, if they, I don't believe they'll fund for the attorney to go, meaning Ashley. If they don't, it's possible that we're just going in August for the full annual. It's just one of those things that we can definitely vote and move the justification memo for 3 funded members. And at this point, Jed, you don't necessarily have to decide if you can or
Okay.
want to go. We can vote that route.
Yeah, and Jed, I know
Would go,
he
yes.
can definitely go in August as a new member.
Oh, the Southern Zone, he may not.
Southern
Okay.
Zone, I'm not sure that he can go, but he can definitely go in August to Washington DC.
We would need a motion for 3 funded members.
If I would happen to be elected Southern Zone Vice President, then I would still be out in our terms, but if I would happen to not be elected, then I'd be back in the mix. Maybe. No, we transition, we actually transition after that meeting, I think it is. Anyway, that's fine. No big deal. We'll figure that out when we get there.
So I would say because May is around the corner and to not leave it to the last minute in April, we want to do a motion for the funded members and for, Ashley and I to go. I don't believe that the May is going to work for me. I know we've both already penciled in August to go to the annual, so that's a given.
I think you got to turn it in by
Yeah.
February 13th.
Yeah.
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 Okay, well, I'll go ahead and make that motion then.
Okay.
For was it the 3 funded members, is that right?
A second.
Okay, have a motion second. All those in favor?
Aye.
Aye.
Okay. All righty. Any other business prior to applications?
I believe we are on to applications.
Okay,
That is where we're at. And I think, so on your iPads, you're going to have to tap out of the presentation itself, and you're going to see 2 documents that have the word application in them in your library. Jamie, is there any particular one that they should divide and look at? We have review for Morrell and Henson. That packet has 2 individuals, and then Fleenor, Fish, and Miller has the other one.
I gave them all the pages.
Of what they need to look at.
Two in one folder, there's 3 in another folder.
Okay, so we got, the first one is Morrell and Henson? Yes. Okay.
Tim, if you want to divide them up however you see fit, so we don't overlap and have 3 people looking at one of them.
On Fleener. There we go. Aaron Fleener.
Oh, pardon me.
Gentlemen, as much of this as I can stand, I'm going to.
I'll make a motion to adjourn.
In that case, next quarter. See you, Rob.
See ya.
Take care, Gail.
There you go. Be careful, buddy.
Jamie, see y'all.
move our meeting to the 5th floor?
Won't be needed once we have the new process. Remember, this month is about as bad as it's going to get.
What you're saying, we can bring our laptops and sit here and do this on our laptops?
Oh, you'll be able to do it at home in your sweats or nice warm
Not if the
clothes.
application just come in, we're having to do it here like these.
Well, these haven't just come in. These are finished, sort of, but it's the system that wasn't working for you all to be able to review them through the WinSep. That's the problem with these. I think our last-minute things, you'll still be reviewing at home on your own time and then sending them back rather than here. So that's the goal.
Good.
You can guarantee
That's
that.
good to me.
Moving on, he said.
I see them all day long. I love them, all day long.
If that's all we saw, it would be
Yeah.
different, but we don't see
Right.
those.
Right. I'm for not making it mandatory, just because it has an expense behind it. But I can fly through those.
Well, you learned
Yes.
that's not.
Yes.
Not there.
Yes. That.
Had one here a couple years ago that the record was 06.
Reference records or,
The
okay,
NCAA record was 06, he never updated.
okay. Well, but we can require them to update it, and then that's a whole other problem. That's on us.
Wow.
Yeah, turn your head, Ted. That's what you can turn your head.
Oh, I got all this, and I want to turn it like this,
I bet
and
Jed
it
can fix
rotates
that.
the other way. And it
Where's
won't.
Jed? Jed can fix that.
Can't you lock screen so you can
It's
turn
been
it?
scanned this way, and when I turn it so I can read it and blow it up, it turns the other way. And I can't read it sideways.
Let's see here. I'm not doing anything else. All right, Tim, here's what you're going to do. Swipe up from the bottom on your screen.
I got it stuck in one place now.
Well, it's now turn it. Now it won't do anything.
There we go.
What do you think?
Look at that, Jed.
Tech support, tell you what.
There you go. You didn't realize you can get into that. did you?
Invoice.
Are we voting on these today? These applications?
No, you want to leave?
Oh, yeah, I'm
That's a personal, Jed. You want to leave?
totally personal. I'm ready to
I
leave.
mean, I'm all about helping you out here, bud. You know what I'm saying? You've listened to me long enough. It's time you go play with the babies. They let them jabber at you.
That's exactly right.
Wait a minute. We're losing tech support. Wait a minute.
Yes, and hand it back. Oh, no, that's yours now? Yeah,
Yeah.
you scan it and hold on to it.
All
You're
right,
good to
got
go.
it.
Thank you.
Take care, guys.
Take care,
Thanks, Jed.
bye-bye.
Be good.
Have a safe
I
trip.
have to scan them.
We do.
That's my jacket.
I approve.
Where's he at?
Oh, yeah.
Tommy Young, but he's working. Yeah, that's where it gets good. Yeah, okay, you're in the good part there.
Apparently, he's complied to his.
He did?
All that's been corrected. The legal structure. application shows that this Joe Ayler is that's hard to tell from here.
Not that I see.
I think we got Craig squared away. I'm going to defer him again.
Yeah, I was about to do. To hear a little more of his explanation of the Kentucky issue.
We did one thing. We asked him to do three things. He did one. I mean, I don't know how hard it is. We wrote it in black and white.
That's why I got to.
I think those are,
Yeah, we're ready. I mean,
those are good.
we have an application, Miss Roxanne.
Oh, you're right.
You want us to read out the
They may
name or
have
whatever? Joshua
And-
Wayne
and
Miller.
They both
Joshua
deferred,
Wayne what?
so I don't have to do
Miller.
anything on
Miller, Mr. Miller, yes.
ma'am.
So, I mean, all that
He has,
can be thrown
for
back.
lack of a better term, an interesting application. And he has some omissions, and I think that it would be prudent if he would come in and we talk to him.
Has he been given already a list of the items? So I take it he's been deferred before, and we've given him a list of what's
First time I've
missing.
seen it.
Oh, okay.
Yeah, I believe
First time I've seen
Oh,
it.
first time. Okay, okay.
Yeah.
So there's no way to really tell him what's missing. The board would prefer to have a chance to meet him and ask him questions.
I wouldn't say so much a specific issue, rather that we just like to
Okay.
ask him a few questions.
Okay.
You know, in person type thing. He's a local Nashville resident as well. I believe his current address was. I don't think travel should be an issue.
You know, the one thing I could tell him is that he needs to review the standards for his plats. I can definitely tell him that.
Yeah.
And I mean, I can cite several, you know, standards things that are not there.
If you don't mind, if two of you have reviewed them, to list the items so that we can send him the letter, and then we will send him either via email or just separately a letter asking him to appear before the board at the April meeting. But since he's going to be months, probably or hopefully he can at least update some of those things.
Oh, it's sad. We sit here and review these applications, and the ones we defer, it's the same item every time, which tells me one of two things. Either the applicant is not paying attention, and they just send something, or we need to, like a hand-holding, we need to be a little more emphatic about the plats or whatever. It's very simple. It says it must meet our standards of practice. So get them out, look at the map, look at the standards, check them off. You know, I'm not going to provide them with a checklist, but it's the same thing. iPads are rough on the eyes.
Oh, yeah.
Because you got it up and up, you know. See, like most of these plats, what I would do if I was doing it in my office, I just go run a print of it. Then I'm looking at a piece of paper that's this big, you know what I'm saying? It's real easy to see, and I can mark it and write it down and be done with it. But that's just me. I'm weird. I'm going to go with that right there. I don't have any more you wrote on it.
Yeah, that's interesting.
I'll vote.
If he just left it as Kentucky, I'd been fine with it.
I think we have come to a conclusion.
Wonderful. We are ready.
I made Miss Ashley smile. That was good. And Miss Jamie, too. We've got the last sheet on Mr. Miller,
Okay.
so Mr. Kaufman respectively requests that Mr. Miller come in and describe his scenario with his disciplinary action in Kentucky if that's not out of order with legal.
You can. We're fine with that. So in his particular case, we're going to send him the forms that you all completed saying that he needed to review the standards for the plats and then any other items you see fit, but that we'd like him to appear before the board to discuss any discipline that he had so that we can proceed with that.
Just his
Sounds fine.
Okay, I think we've concluded application review. It's now 3:20. Rubbed and rubbed and rubbed. We don't want to ride at all. New, so much for newness. Right. So we had,
Go ahead and make a motion for approval of 5 PDH hours for today's working efforts.
Second.
have a motion and a second. All in favor?
Aye.
Okay. Ms. Roxanne, you have anything else for us?
Before we adjourn, at the last 3 meetings, I think, we've gone ahead and on the record read the applicants that we've had to review. Now, we haven't had 5, so I know this time's a little bit more. But if I could, and I don't know if you have it or Jamie can add to it, I know what we're doing with Mr. Miller. On Mr. Fleenor, are we approving or deferring?
All the things. They begin to run together. I apologize.
I know, I agree. I just know that that's what we need to do on the record.
Couple right here, yeah.
No, that's, well, it might be.
Is deferred. Mr. Fish?
Approved.
Thank you. Morel?
Deferred.
And Benson?
Approved.
Okay, so we have 2 approved that we will be issuing to move forward, and 2 we will send the information for their deferral, and 1 is being represented in April. That is all that I've got. Thank you.
No one has anything else? This meeting is adjourned. You may turn the TV off.
Did we motion?
We have a motion to adjourn.
We adjourn.
And second.
Thank you.
Motion second, and we eyed it and we're ready.
Hey.